Well, the children is balance out. They are already, they law. Standard of leniency, and as I will change other.
Thank you, Mr. Cranmer. Good morning. Oh, Molly, when I was a trial judge and I was picking juries, when I'd say good morning and then it was so quiet, I knew we were going to be in for a long morning. So we'll try one more time. Good morning. All right. Excellent. Very good. Good to see everyone. Thank you so much. It's my privilege to serve today on this panel of the Michigan Court of Appeals, sitting in Grand Rapids with my friends, Judge Wallace and our new judge, Judge Levency, who is also becoming a friend. It's my privilege to welcome you, Judge. Thank you so much for standing up and putting your hand up and saying you're willing to serve. The governor, as usual, as all of our governor's decisions in this administration and previous ones, added great value to our court. The judge is a University of Michigan law grad, Ohio Wesleyan undergrad, worked for the great Senator Carl Levin for a time, and after my own heart was a federal prosecutor for 16 years, as well as at Honigman Miller. So outstanding lawyer, outstanding person. He is the father of a great athlete. I don't know if he is or not, but at any rate, we're glad to have him. And we're glad to have Judge Wallace as well, of course, who's also appointed by Governor Whitmer. But it's our privilege to be here today, and we've reviewed all of your cases. There are 12 matters on our docket today. Some of them have individuals who are either actual victims or alleged victims of sexual misconduct. If you have one of those cases, we ask that you refer to the complaining witnesses or the victims by their initials. If you have a custody case where there are children involved, you also need to refer to them by their initials. The reason for that is these matters in some ways are either live streamed or will be made available on the internet virtually immediately after we're done with our oral argument today. I see many of our litigators here today are individuals who have the privilege of serving on your cases frequently, so you know that, but there are also a few new faces as well. So that's the first order of business. Second is the three of us have had very substantial communications between one another on many of these cases. I would say in the 8.5 years I've been privileged to serve on our court, it's one of the most robust series of communications pre-oral argument that I've experienced. I share that with you because I'm proud to serve with these two judges, as I am all the other judges of our court. But to point out, we know the cases. We know the facts. We, I think, understand what the legal questions are. Please do not get up and tell us in the beginning God created light. We understand that, so just get to the salient points. And I suspect you're going to have a lot of questions in several of the cases today. So we appreciate everyone's briefing. The vast majority of the briefing was extremely helpful, and we're looking forward to your cases. Judge Wallace, anything you want to add before we get started?
Oh, thanks.
Judge?
I'd just like to thank you for your kind remarks, and also mention that it's a pleasure to be here as well. While I was appointed to and represent a different district, I'm a native West Michigander and happy to be back closer to my place of birth. So looking forward to the arguments today. Thank you.
Right. And I will say we had the privilege to meet Judge Levency's father, and I'm not going to say who he is in the courtroom with the blue plaid sport coat, but if he gets emotional because he sees his son doing such an exceptional job, you'll have to understand. And I told him no cheering at good questions and no booing at bad questions for the other judges. So at any rate, thank you, Judge. All right, with that, we'll call our first case, the matter of the people of the state of Michigan versus Perry Linnell Pierce. It's case 364-779. Oral argument is reserved for the defendant appellant. Excuse me just a moment. Okay, great. Thanks, Ruth. All right, counsel.
Good morning, Your Honors.
Good morning.
Roman Tishkevich on behalf of Mr. Perry Pierce. Your Honors, I believe the record is clear in this case, and Mr. Pierce's request for new counsel is unequivocal and persistent. The record shows, and the trial attorney conceded this, that he made this request for months before trial. He made this request to the trial attorney at least 6 times before trial. And the trial attorney never informed the trial court of this request, which I think is concerning in itself. I think the trial attorney had a duty and obligation to inform the trial court that his client was trying to fire him, was trying to get a new attorney. And Mr. Pierce sent a letter to the PD's office months before trial, and the PD's office denied his request for reassignment. He requested the trial court 10 days before trial 3 times. He said, I want to fire my attorney. I want to fire my attorney.
That's not what he said, though, is it?
He says, I want to dismiss my lawyer. I don't want him as my lawyer.
And then he didn't actually ask for a new lawyer, right? He asked to represent himself.
After the trial court told him, you can't do that. You don't get to choose your lawyer when the public defender office represents you. They assign a lawyer, and then he requested.
I guess the reason I ask is you say there's these weeks or months of requesting new counsel with prior trial counsel. But when he did actually have the opportunity, your client did, to express his request for new counsel on the record. He expressed what he expressed. We've all read it. Is that, I guess, in that situation where he basically says when he immediately pivots to, I want to represent myself. Are you saying there's a requirement by the trial court to ask and to inquire about whether he had good cause for a new attorney immediately upon when Mr. Pierce pivots to, I want to represent myself? In that situation, are you saying the trial court was obligated to make inquiries about possible good cause for a new attorney?
Yeah, and we have to look at the circumstances before that pivot.
But the trial court didn't know that, right? Like, I'm just saying, when the trial court is faced with what the trial court is faced with, I want to represent myself. Are you saying that they then have to not take that path, but instead inquire as to good cause for a new attorney?
Yes. When Mr. Pierce, for 3 times, tells the trial court, I want to fire my attorney. I want to dismiss my lawyer, he says. I don't want him as my lawyer 3 times. And the trial court should say, why? I mean, that's the question. And the trial court should investigate that reason. Why are you trying to dismiss your attorney? And Mr. Pierce, for months has been trying to get a reassigned attorney. He asked the PD's office. He asked his attorney every meeting, I don't want you as my attorney. Could I have a new attorney? And his attorney said, I never told the trial court. I never informed the trial court of that reason. And when we asked him at the Ginther hearing, when I asked him, I said, why didn't you do that? He says, well, I couldn't. I was forced to represent him. I couldn't withdraw. And then the trial attorney was his standby counsel. And I asked him, why did he do that? And he said, because I could not withdraw as his attorney. And then we went through the policy and we say, there's no policy allowing you to stay on as attorney.
If I could just clarify with respect to my question, is there any specific case you're citing to as to this obligation to inquire as to good cause, even when someone says they want to represent themselves? Is there any particular case you cite to besides McFall and Strickland that you'd like me to focus on?
In regarding to fire his attorney for the trial court to investigate?
Yes.
No, those are the cases that are cited in our brief. Is saying that the trial court, when an attorney or when a defendant, when a person asks for a new attorney, the trial court should investigate. Why? Why do you want this? And on October 10th, when Mr. Pierce was denied his request for a new attorney, he wrote a letter to the trial court that day. That day, he wrote a letter that the trial court received 2 days later. And he detailed, he goes, I've not seen my attorney. I've seen him twice in 4 months. I've not received the police report. I've not received any of the evidence. I would like to see this evidence before trial, 9 days later. And the trial court ignored them.
there's some evidence that I think that the initial assigned attorney became standby counsel, that he felt physically threatened by your client. Is that correct?
That's correct, yes.
What should a lawyer do when faced with that situation?
You should ask to withdraw. He should, and he should bring this immediately to the trial court's attention. He should say, you know, I cannot represent, there's been a total and complete breakdown of the attorney-client relationship. I cannot represent him. And this was the
This
first,
was an assault of a corrections officer case, right?
that is.
Did counsel say at the Ginther, did he address that at all? That played into whether or not he communicated to the court?
I don't believe he did. At the Ginther hearing, I don't think he was not telling the court because
So he never said, hey, the reason I didn't tell you, judge, is it was a dangerous situation and the allegation was he did dangerous things. You know, he didn't
Right.
say anything like
right.
that.
I thought there was testimony on that at the Ginther hearing about basically not wanting to disclose to the court potential violence for someone who was already charged with a violent act or something to that effect. But
And I don't, and
Is-
if
I
it
guess-
was, I don't recall.
a follow-up to Judge Bedford's question, though, is it necessarily ineffective? Because I think that's the issue we're dealing with, right? There's a what the lawyer could have done or should have done, but then is it ineffective for failing to?
And for failing
For failing to inform the trial court of feeling physically threatened.
yes, and that's what we briefed in our brief. And we indicated that he was ineffective for failing under the Michigan rules of professional conduct, under specifically 1.16B. He had these reasons to withdraw, all these reasons, and he did not inform the trial court of any of the reasons. He testified at the Ginther hearing that he only communicated via letters with Mr. Pierce. And Mr. Pierce's history,
Right, but I mean, and sometimes I say this too much, but you know, you've been on panels that I've served on. I had a job down the street for 12 years and 6,000 felony cases. And I had, there are times when people don't, the relationship is not great between the attorney and the client, and is communicating by letter. Is that evidence of a specific breakdown? If the lawyer's like, every time I go in to see him, he just gets all excited and angry and mad. So, he's an angry, mad kind of guy, and I send him letters. I mean, is that indicia of ineffectiveness?
the trial attorney testified that we had a mutual interest in not representing Mr. Pierce. He testified at the Ginther hearing.
Okay.
There was a mutual interest, and we cited that in our brief, of me not being his attorney and him not being his client. I don't know how much clearer the record can be
Okay.
regarding that. So he never informed the trial court. And then Mr. Pierce was, so it's got to be unequivocal. It's got to be voluntary, the waiver. And Mr. Pierce, in desperation, and he had an attorney before that. He had an attorney before that. I had no problems with that attorney before that at the arraignment, Mr. Schlacky. And Mr. Schlacky.
Was he from the defender's office too?
Yes. And Mr. Schlacky left the defender's office and in fact represented Mr. Pierce in a civil matter afterwards. And he had a problem with this attorney. And then he didn't have he got a new attorney at the sentencing. He didn't have a problem with that new attorney, Mr. Tolman, at the sentencing. And the trial court, for whatever reason, said, no, you don't get one for the trial, but I'll give you one at the sentencing. I'll give you a new attorney. You have to represent yourself. Because he, in desperation, Mr. Pierce said, then I want to represent myself because I cannot have him as my attorney. And then he asked for an adjournment. He said, I haven't seen the evidence. And the record shows that. The record from the prosecutor and his attorney says, yeah, we got the video late. And at the day of the trial, they showed him the video that he's never seen before. And the circuit court who decided this matter after, or who we did the Ginther hearing on, said that, that video really didn't show anything or, but that was the incident. That was the incident that Mr. Pierce was trying to defend himself with. And it would show the witnesses, it would show what other information he might get. It would show what they saw. So it was crucial. And the trial was held 109 days after the arraignment. And in Berrien County, I've had cases where they've been 2 to 3 years,
Nice, moving it right along.
You're right. And so they went from the arraignment to trial in 3 months. Without a request, with saying, no, we're not going to give you an adjournment. Too late. You got to represent yourself. Oh, and you have this history of mental illness, which we have an expert that said he was not criminally responsible by looking at his history, at his records, at the Lakeland Hospital record, which his attorney they weren't in the record. We were the first ones to get those records from Lakeland Hospital.
Just to clarify, is that the July 2024 expert report?
Yes.
Yes. So there was the intervening fall 2023 report, but that didn't opine on 2022, right? It was just the July of 2024?
That from our expert on criminal responsibility.
Okay.
And then there was a competency report and he was found not competent. Not competent. And I forget that day, they might have been the 23 or maybe that was 24. I think that was the 23 where he was found not competent.
Can I ask you about the standard of review? And we have a motion for a new trial, which is typically reviewed for abuse of discretion. Some of the issues, I don't know that but while you have a section called standard of review, it's not our standard of review per se, it's more the legal standard. With respect to the 5 issues, are any of them de novo or are they all abuse of discretion, or what is your position on that?
So the standard of review for the new trial is abuse of discretion for the circuit court. In this case, it wasn't the trial court, it was a circuit court that did the Ginther hearing and reviewed. So it's an abuse of discretion regarding her factual findings of the law. This court can look at constitutional issues de novo. And in this case, when we allege, that there's been a complete breakdown of the attorney-client relationship, we believe that it is structural error. It's automatic. There's no harmless error in this when a client does not get representation. And also the Supreme Court case, Michigan Supreme Court of People v. King, when they looked at a valid waiver, in that case, that client or that person also asked to represent himself. In that case, they consider that structural error. There is no harmless review.
So what's the burden then? If it's structural and it's established as structural error, who has the burden of showing that the error is not related to didn't impact the proceedings? Does it shift the burden of the prosecution?
If it's structural error regarding error,
Yes.
then it's automatic. There's no.
Has to show the error.
I believe we have to show the error. We have to show that it was structural error.
By a preponderance?
By a preponderance.
Okay. Good. All right. You have about a minute left if there's anything you'd like to wrap up with.
If any other questions, I'll be more than happy to.
No, we always appreciate your appearance on these cases. You do a commendable job. So thank you, counsel.
Thank you so much. Thank you.
All right, matter submitted, case call number 2, case 370817, People of the State of Michigan versus Brian William Helfert. 3 attorneys are endorsed, Daniel Patrick Kelly for plaintiff appellant, Kala Serino for plaintiff appellant, and Michael Middlestad for appellee, defendant appellant, Michael Middlestad. Okay. And substituting for Mr. Middlestad, I was handed a piece of paper. Yes, Dan, I was paying attention. I just misplaced it for a minute. We have Is it Ms. Emma Klug?
Yes, that's
Okay.
correct.
Are you a student?
No, I'm a new attorney
Oh,
with the State
congrats.
Appellate Defender's Office.
All right. Have you taken the bar yet?
I have, yes.
All right.
Yes, and passed.
No, congratulations. Welcome. Have you been before the Court of Appeals previously?
This is my first time.
Well, welcome. All right. Let's get out the hard question notebook and ask, sure we ask the good ones.
Yeah.
All right. Counsel, thank you. Please proceed.
Good morning, Your Honors. Assistant Defender Emma Klug with the State Appellate Defender Office on behalf of Mr. Brian Helfert. We have two sentencing issues before this court today. The first is that the trial court was wrong to score OV7 at 50 points. And the second is that the trial court erred in exceeding the guidelines in Mr. Helfert's minimum sentence. To begin, Mr. Helfert and the prosecutor both agree that OV7 should not have been scored at 50 points for brutality. So we'll move on to the next point of contention, which is that the trial judge erred in ruling that OV7 could be scored 50 points because the conduct was intended to increase the complainant's fear and anxiety. This is supposed to be scored if the conduct was designed to respond to particularly heinous instances in which the criminal acted to increase a victim's pain, fear, or anxiety by a substantial or considerable amount. And so what we look at when determining this, there's two parts to this test as laid out by this court's case in People v. Alexander. And first we look at whether what conduct the defendant engaged in beyond the sentencing offense, and then whether that conduct was specifically designed to increase the fear and anxiety. And so here, the sentencing offense being a CST2 was the touching for sexual reasons, and then the fact that Mr. Helfert did have a gun on him. The other conduct that we're looking at then is that there was this discussion of lump checks, that there was that's what the touching was done under the guise of, and that there's pornographic magazines brought into the school.
Right, but the defendant is a sworn law enforcement officer in full uniform, wearing his duty belt, which includes at least a firearm, we know for sure.
Mhm.
He has been the school safety and resource officer since the victim was in the 4th grade. And he has developed this relationship with the victim. And when he commits these acts of criminal sexual conduct, he is taking him to a secreted away room. He's locking the door and he's doing this. I mean, how is it an abuse of discretion? Because that's standard review, correct?
Mhm.
How is it an abuse of discretion for the trial judge who presided over this to conclude that this is sadistic, this is brutal, this is activities, that are so beyond the pale, the 50 points should properly be scored?
So, yeah, we certainly don't argue that this behavior is not inappropriate or that it's the facts are strange and unconventional.
Straight.
Yeah,
He brutally sodomized a child multiple times. This is not unusual or peculiar. This is violent criminal activity.
mhm.
So let's call what took place for this defendant and what he did what it is. The question is,
Mhm.
did the trial court abuse its discretion on the 50 points?
We say yes, that the trial court did abuse its discretion here. Looking at the case law, that we have instances in People v. Hardy where there's the racking of a shotgun, which makes the victim believe.
Is
that they're
there
going-
any, that there was a course of conduct which lasted over 5 years? Any of the cases you've cited?
Oh, excuse me, just to clarify, is the conduct going on for a period of time? Is that what you're asking?
4th grade, the victim was in high school.
Mhm.
So the least number of years is 5 years that this grooming activity is taking place. Are any of the cases that you have cited involving conduct that was 5 years or longer?
To that question, no, like the cases that we've cited don't involve the same sort of ongoing years of conduct, but because this is a McGraw variable, the conduct that we have to consider here is conduct that involved the specifics of the sentencing offense, which is related to those couple of years in
Right,
high
right.
school.
But those couple of years where this child is being victimized by your client could not have taken place but for the precipient events of the ingratiating oneself into this society, these friendships. Yes, we're limited for the sentencing guidelines to the specific conduct giving rise to the conviction. But if there are events leading up to it, is the court required to not even consider that?
The court can consider it, but for OV7, the court needs to look at the behavior surrounding the sentencing offense itself, whereas the trial court was able to look at OV10, which scores vulnerability and predatory behavior for the sort of examples you're giving leading up to the sentencing offense. And that was scored in this case.
I appreciate the distinction because I am curious to Judge Redford's question. How long, I guess from your perspective, I have the same question for the prosecution is like, how many months was the criminal offense occurring? Because it says kind of started around 16, continued into 17. But I guess my question is, once the victim turned 18, is the criminal offense still happening or not, right? Once the person is.
Yeah, because they're a student.
Okay, so is it once they graduate? I guess, you know what I mean? I guess that's what I'm trying to understand. When did the criminal offense start and when did it stop? Because once the person graduated from high school and moved in with
Yeah, if you're an adult.
yeah, so I guess what's your position as to the starting month and stopping month and how many months overall?
Yeah, with this trial taking place so many years after the fact, I think it was difficult to pinpoint exact months. But the tutoring began in sophomore year when the complainant was being tutored with another student. Then he continued on to be tutored individually. And at some point, maybe around the middle of his junior year is when the conduct began where he was feeling itchy and Mr. Halford applied cream. And then over the next year and a half or so is when these instances continue to occur prior to, and then eventually you're correct, he graduated and we're not really considering the conduct outside of that.
So if we accept your position, does this change his placement in the sentencing grid?
So no,
So would he even be entitled to resentencing then?
our argument is that although rescoring of OV7 from 50 to 0 points doesn't change his position in the grid, it would still warrant resentencing because the OV7 consideration was a large reason why the trial judge decided to depart in the extent that she did. Mr. Halford had 125 OV points, and in his class C grid, the top of the OV was 75 plus. So the judge sort of remarked that he had these 50 extra points that she sort of had to account for in departing in his sentence. But if OV7 was changed from 50 to 0, that puts him squarely at the top, and that there's not this exact math that's considered, but it does somewhat change the calculation of how she was getting to her departure. And because the departure was as large as it was, his sentencing, or excuse me, his guideline range was recommended at being about 2.5 years to just under 5 years. She gave him a 9-year minimum. So it is a large departure that's then not explained, especially with OV7 potentially being changed.
Good.
Okay.
Anything else?
I will at this time just save my time.
Okay.
For rebuttal.
All right. Thank you,
Thank you.
counsel. Appreciate your advocacy on behalf of your client.
Thank you.
Okay.
Good morning. May it please the court, Assistant Attorney General Daniel P. Kelly on behalf of the people.
Mr. Kelly, please proceed.
Thank you, Your Honor. This case comes down to two straightforward propositions. Number one, OV7 or offense variable 7 was properly scored at 50 points under multiple independent bases supported by the record. And even if the trial court did err in scoring OV7 at 50 points, The guideline minimum would not change. There's no change in grid. And the trial court made it clear that it would impose the same sentence based on extensive and valid objective reasons stated during the sentencing hearing. For these reasons, the sentence must be affirmed. I at this point in time would rely on the argument made in our brief and be open to answer any questions the court may have about our position.
If you take 50 points away, that's a big amount to take away and not send back for resentencing. I understand the grid has not changed and I understand, but do you have case law to support that proposition that you're
I don't have case
supporting?
law to support the specific of 50 points. I do believe it is Michael Anderson is the case cited in our brief that talks about if there are, if the court lists some valid reasons for departure and maybe some invalid reasons for departure, as long as there are invalid reasons and the court indicates it would done it the same. Either way, there's no need for remand. That's probably the closest case I have. I don't think I have anything directly on point to answer that question, Judge Redford.
Thank you.
I have two questions. And one is based on a deficiency on my part. You said that the trial court said they would have resentenced, even not scoring, would have sentenced anyway. Is there a page of the transcript?
Yeah, Your Honor, I believe it was indicated. I don't know the court said it outright, but I think based on the court's explanation, it was implied that they would do so. And if you give me just one moment, I can give you a page number. My apologies for not having that readily available.
Well, my apologies for not.
But I do believe it is page 82 of the sentencing transcript. And again, I don't know that it's overt, but it says the scoring total of the OV is 125. I believe that is also insufficient under the guidelines, not scoring 125, but the fact that the Class C OV level 6 maxes out at 75, and here we're at 125. So there's 50 points that's really not under the guidelines, if I ever follow them, are not even considered or scored in the determination of the potential and appropriate penalty.
Well, that's the basis for the departure.
That is
That's
one of
not
the many
saying
bases.
that's not one saying I would have sentenced the same way, even not scoring the 50 points.
Yes, Your Honor.
Okay.
But I do believe as he continued on talking about how Mr. Helfert woefully betrayed his badge and then continued.
I understand it wasn't the only reason. I know. But the other question, again, the same question I had for the defense. When did the conduct start? When did it end? Or approximately how long in terms of years or months is your position that the criminal conduct, offense conduct occurred?
That's so I believe that our position is the criminal sexual conduct started in September of 2006 and continued on until graduation, which would have been around June of 2008, when although the victim would have potentially been 18 years old, he was still a student, and that was the charging theory. That would be volume 2 of the trial transcript, pages 213 to 215, as well as page 218.
So that's more like 1.75 years instead of 1.5 years.
Well, yeah, well, I don't know that we could say it that way because we have to look at it as a school year, right? School's generally running from September to June. So
I understand.
So I don't know that it's continuing. I don't know that I have facts to say it continued through the summer.
Okay. Okay, that's fair.
Judge Wallace. Any other questions, Judge? All right. Thank you, counsel.
Thank you.
Ms. Klug?
Yeah, I just want to briefly note that at sentencing, the trial court judge did not say, I don't think she implied it, nor did she overtly say that she would have imposed the same sentence regardless of OV 50 or OV 7 being scored at 50 points. Of course, she did note some other reasons for her departure, but with OV 7 weighing as heavily it did, that's why resentencing would be warranted if this court found OV 7 should change.
All right. Understand your position. Anything else?
No, thank you.
No, thank you.
All right. Thank you, Ms.
Thank you.
Klug. You did very well in your first argument. So wish you many, many happy returns of the process. So
Thank you.
thanks. All right. Matter is submitted. Case number 3 is 367024, People of the State of Michigan versus Justin Amir House. Endorsed for the defendants are Taylor Fellows and Catherine Swedlow. Endorsed for the plaintiff is Kimberly Mans. Morning.
Morning, Your Honors. Taylor Fellows with the State Appellate Defender Office here on behalf of Mr. Justin Amir House. This court has not had the pleasure of meeting Mr. House, but I do hope that it has had the opportunity to learn more about him through the declarations offered to the court, as well as the record at his sentencing, where over 20 letters of support from this community were offered. Members of the community describe Mr. House as, and I quote from one of the declarations, an exceptionally peaceful man. He has a reputation as a peacemaker in my family and in our community. I've never known Justin to be violent or even argumentative. In fact, I have personally seen Justin diffuse tense situations, advocating for level-headedness and reconciliation. These are words from Ms. Margaret Taylor, a member of this Kent County community, excuse me. The declarations offered to this court are just a taste of what the members of this community can attest to when it comes to Mr. House's reputation and character. Not every case needs character evidence, but when you have someone with an exceptional reputation and character in the community, like Mr. House, accused of acting in a way that is so contradictory to his typical character and reputation, that evidence is highly relevant. However, at trial, despite the prosecution's attacks on Mr. House's character, Mr. House's defense counsel failed to provide the jury with character evidence of Mr. House's honesty, reasonableness, and peacefulness. This was objectively unreasonable, where he raised self-defense at trial, and evidence of his reputation for peacefulness and reasonableness would have made it harder for the prosecution to disprove self-defense by a reasonable doubt. Additionally, Mr. House's truthfulness and honesty, evidence of his truthfulness and honesty, would have helped the jury weigh Mr. House's credibility in his statements made to police that he heard the decedent say, "Bro, shoot him," and that he saw the other individual reach for what he believed to be was a gun. This is also objectively unreasonable, where the prosecution painted Mr. House as the aggressor here. She said that he was out for vigilante justice and that he took matters into his own hands and described him as hunting for the teens. The prosecution also challenged Mr. House's honesty, saying that his version of events was not true and suggesting that Mr. House lied to the police about his weapon, that he tried to hide his weapon, which if the jury had heard evidence about Mr. House's truthfulness, they would have accepted his account of events when he told the police, "I wasn't trying to hide the gun, I was mistaken. One of the guns is missing." And it was later learned that, in fact, one of Mr. House's weapons was reported missing and remains missing to this day. Mr. House was clearly prejudiced here by these failures. He has a remarkable reputation in the community, as indicated by the declarations, and by failing to address the prosecution's theory that he was the aggressor, that he was untruthful, trial counsel essentially allowed the jury to assess the evidence.
Did he testify?
Mr. House did not testify, no.
How do you get admitted as evidence reputation for truthfulness if a witness doesn't take the stand?
Here it would have been to directly rebut. You can admit evidence of his truthfulness where the prosecution brings it into question. He has testimony, his account of events comes in, right, through video evidence of his interrogation or conversation with police, where he says exactly what happens. He says, I thought I saw a gun. I heard him say, "Bro, shoot him." And I acted in this way. And also when the prosecution says that Mr. House lied about his gun, that also comes up in his conversation with police, where Mr. House says the police actually try. Do
you have a case where the appellate courts of this state have found it reversible error to not allow character witness in a criminal matter where the defendant does not testify? Is there any published case in Michigan that holds that? Or any state in the union?
Your Honor, none come to my mind at this time, but it's not just about his character for truthfulness that we're talking about. It's also his peacefulness and his reasonableness. Those also come up at trial. And if the jury had, and that goes directly to his defense of self-defense, his reasonableness, whether or not he was acting reasonably under the circumstances, and whether his apprehension or his fear for his life was reasonable in those instances as well. He's said to be a very peaceful man in the community. He's seen to have diffused situations. He's seen to uplift Black members of the community, not gun them down in the street as the prosecution paints him out to be at trial. And
If I
so,
may, I think rather than having the defendant testify, you're saying that it was that these other witnesses could have testified under 404A2, sort of an exception to the generally character evidence is not admissible for criminal defendants. There's that exception. But slightly different question than Judge Redford. Is it necessarily ineffective assistance of counsel, in other words, deficient performance of counsel, to not call such witnesses, particularly here where the defense was self-defense and the issue was split-second decision, right? Someone's character for truthfulness or peacefulness is kind of a little bit different when the defense is, I had a quick judgment call, right? This is not a slow deliberative process where I'm going to make a I'm going to consider all the factors, et cetera. This was split-second decision. Is it ineffective to not use character evidence when the defense is sort of split-second self-defense?
yes, first I'd say that I'd love to hear from trial counsel on the record, and I'd love for you to have that. And I'd ask for an evidentiary hearing to call them if you're not satisfied with how we've briefed it today. But yes, it is still ineffective assistance here where his reasonableness is still a question. Whether or not in that split second he was reasonable to act the way that he did is exactly what we're raising. And to the extent that Mr. House didn't testify at trial, it's ineffective assistance here where the counsel didn't consider or investigate character witnesses. If they had, perhaps Mr. House testifies at trial. This clouds the entire defense. It impacts his self-defense claim. It also impacts, how the case even progressed. And so they didn't here move with sound trial strategy because they didn't even consider it. And I think that that's clearly deficient where, again, Mr. House has a remarkable reputation in the community. I'll move on because I know my time is short to the next issue unless you have any questions. Mr. House also has a Sixth Amendment right to present a full defense, and that was denied here where the court preemptively forbid evidence of the decedent's reputation and character in the community for violence and aggression. This is a preserved constitutional error. The prosecution must prove the error was harmless beyond a reasonable doubt. This was preserved at the motion hearing in January of 2023. And here, again, Mr. House raised self-defense, where he believed that the decedent ordered another teen to shoot Mr.
But
House.
you were trying to, the defense is trying to introduce reputation evidence of peacefulness, right? Of the decedent.
Of Mr. House. This is about the decedent's reputation in the community for aggression and violence.
Doesn't Mr. House have to know of that reputation?
No, he does not, Your Honor.
In what circumstances?
People
Ever? You never have to know that the decedent was violent. Is that your position?
in this situation, when
No,
the
that's not
evidence,
my question. There are two ways that this evidence can be addressed, is my understanding.
yes,
One, the decedent has to know it, or the defendant has to know it. The second, the defendant does not have to know it. Do you agree with that?
yes, Your Honor.
Why are the facts of this case in the universe of the defendant doesn't have to know it?
That is because the evidence here is not being presented to show that Mr. House acted in self-defense. That is when you cannot allow it in if he didn't know that the decedent had this reputation. This is evidence of indicating that the decedent was probably the aggressor, to make it more probable that he was the aggressor in that moment. And People v. Harris is very clear here. The Michigan Supreme Court was clear that character evidence of a decedent's reputation for aggression is admissible to render more probable the evidence that tends to show an act of violence at the time the decedent was killed. This is even if the defendant does not know about that reputation. Here, Mr. House is saying that the decedent was the aggressor. He said, bro, shoot him. He was acting in concert with the individual that he was running, who was wearing the red coat. And that other individual turned to, presumably, as Mr. House believed, to pull out a gun. The trial court here at the motion hearing seemed to question whether or not the decedent was an aggressor. But if we just zero in on the teenager's conduct here, I think that it is very clear that he is an aggressor. If
Was
the-
shot in the back. This 14-year-old teen was killed, a single bullet entry in his back that exited the front of his torso and caused his death. How is it obvious that he was the aggressor?
If we zero in on this situation, just the teenagers, if these individuals running, the decedent says, bro, shoot him. If the individual in the red coat had positive or had actually been able to successfully shoot Mr. House, the decedent would have been a co-defendant in murder. He is an accessory. He is aiding. It doesn't matter that they're running together. Yes, so it does make sense that the bullet comes in through the back. But without question, if Mr. House had been shot that day, those two would both be on trial for murder. And it's clear in that situation that the decedent is an aggressor. Here, Mr. House says, bro, shoot him, showing that the decedent is an individual who holds himself out on social media to have guns, to have bullets, to wave them around, and to associate himself with other individuals that act in the same way is highly relevant to the jury. This is not a harmless error here. People v. Harris shows that this is clearly error, and this is not harmless here, where character evidence goes to the heart of Mr. House's self-defense claim. It offers a lens through which the jury can analyze the evidence presented throughout trial, evidence of the decedent's violent character, and that supports the decedent's probable aggression against Mr. House on the night in question. Additionally, this is also not harmless where this was an emotionally charged trial. Trial counsel indicated on the record when objecting to the inclusion of the decedent's autopsy photos that there were audible reactions throughout the courtroom at just a picture of the decedent, of a living picture of the decedent. This clearly shows that the jury had a very inaccurate picture of what the decedent was and how he was holding himself out to be. If the jury had information not only about the decedent's character and reputation for aggression in the community, but also Mr. House's outstanding reputation, his reasonableness, his honesty, his peacefulness, this looks like a completely different situation where Mr. House's split-second decision makes sense.
But the jury did know kind of the events leading up, right? Why Mr. House reacted the way he did. It was the stolen car. I mean, that all came in, right? Like it wasn't, the decedent wasn't painted as some sort of angel here.
Correct. The decedent was painted to be in a car of other teenagers. We don't know their ages, right? They all left in different directions. And then the prosecution says Mr. House was out for vigilante justice. He pursued them. He hunted them. And so it alters the situation here. Instead of realizing that while it may be true that Mr. House pursued them, right? He followed after them for what he describes to police as his wanting to catch them so that they can answer to the police. There you might paint Mr. House as the aggressor. He's following them. He's pursuing them. But then it kind of moves over back to the decedent when he says, bro, shoot him. He escalates the situation, right? And then when his associate then goes and reaches for his weapon, that's a clear act of aggression. And so the jury did not hear
You have 1 minute remaining.
that. So I will quickly move to OV6 unless the court has any specific questions to the other issues. I do just want to say that OV6 should have been scored here at 10 points for 2 reasons. And a departure from the jury verdict is appropriate here, where 1, the offense occurred in a combative situation. And I will say that a combative situation does not have to be the court finding self-defense. It is very different. The court here had evidence of Mr. House's character, the decedent's character, also had evidence that the jury didn't hear about the decedent being a gang member. And this is about
20
whether or not.
seconds.
And so again, the entire situation here took place in a combative situation. I think, as I've already painted previously, I do think that in this situation, a departure and a scoring of 10 points is appropriate as briefed in our brief on appeal. And unless the court has
All right.
questions. I'll leave it there.
For the record, the decedent was 13 years old.
Yes, the decedent was 13.
13, I'm sorry, I said 14. Thank you, counsel.
Thank you.
Thank you. All right. Matter is submitted. Next case on our docket is case number 4. I would ask if there are multiple counsel present, and I don't, case number 4 and case number 5 both involve people of the state of Michigan versus Donald Allen Lucas. In number 4, plaintiff's appellee is represented by Kimberly Manns. Defendant appellant is represented by Mr. Ferrone. I think I saw Mr. Ferrone here. Case number 5 is 369486. People versus Donald Allen Lucas. Mr. Ambrose was endorsed, but we received a submission yesterday indicating he was waiving oral argument. If either Mr. Donaldson or Mr. Ambrose are present in the courtroom, they may be seated at council table with Ms. Manns and Mr. Ferrone. I don't see anybody coming forward, so, all right. So, not much happening in this area of the law. It's, hardly anything developing, so.
I gotta be honest, Klein Smith was my case, and court may know that the Michigan Supreme Court, that was up there with Ellis, and Ellis is still pending, and we managed, to get Klein Smith remanded to this court, and it got resolved. I was happy with the resolution in this court, and Klein Smith was dismissed, and I was relieved because it's not my favorite area of the criminal law. It is, I've struggled with it. Sora, I admit it. In this case, just briefly, Mr. Lucas, we're here on Mr. Lucas's own improper motion for relief from judgment. He filed his own improper application with this court. It was only at that point that I was appointed. I struggled with this case for the reasons I just mentioned. Also, getting the record, I had trouble reading it. Although the judgment was very legible.
Did you had the Ottawa case, right?
No, I've got the
You've got Kent?
Kent County case.
Okay. Oh, right, with Ms. Mann.
And so, yeah. So I ended up joining Mr. Lucas in his error, it's my error now as well, that said that the SOAR is not in the judgment. It is in the judgment. Opposing counsel is correct. I acknowledge
Right.
that.
Thank you. You did. Yep.
I'm wrong about that. It is still true that it wasn't mentioned at sentencing, so that part of the argument's intact. And finally, I would note that the Michigan Supreme Court did release People v. Shaver just a few days ago, which held that the bets can be attacked retroactively in a motion for relief from judgment. Now, Mr. Shaver had a conviction. I don't think Mr. Lucas has a conviction. I don't think he's challenging a conviction. I hope I'm not wrong about that. I mean, it's a really unusual.
No,
form where-
it's a,
where I had really
right.
wondered.
The record should note that in this matter, the defendant appellant is challenging his obligations under the Sex Offender Registry Act and it comes to us procedurally in the case that Mr. Ferrone and Ms. Manns argue from the Kent Circuit on a 6500 petition that the Kent Circuit denied relief to the appellant. It comes to us in case number 5 from the Ottawa Circuit when Judge Bozeman in 1994, I think, imposed a sentence following either a plea or I just don't remember if it was a plea or a trial. And he challenged the SOAR registration there in Kent. I think it's Judge Rossi was the trial judge most recently. Judge Booth was my old suite mate, was the trial judge initially. In Ottawa, it was Judge Bozeman was the trial judge, and most recently, I think it was Judge Halsing. So in light of Shaver, and Shaver was decided May 29th, 2026, and today is June 2nd, 2026. So we're all working on trying to get up to speed. I know my colleagues are a lot faster at that than I am, but anyway, what do you what should happen in light of Shaver? And also last week, a published case was released by the Court of Appeals that I was on the panel of. Judge Murray was the author, that also addressed SORA. So where are we?
I don't know that case. I think your honors got a better, hate to say,
I have a
better grasp of
I have a
this.
law clerk and a judicial intern helping me. So I'm cheating because I have really brilliant young lawyers who are assisting me.
That's a kind way to appreciate that.
So
Well, I think
the
opposing
most
counsel,
recent one from Judge Murray and myself and Judge Rick was Shannon. That was last week.
I think I saw it. I can't say I've read it close enough to even
Right.
comment on it. And
That one dealt with the 2021 amendment, I
It
believe.
did.
So
It did. It's a little different.
it's
not- yeah,
interesting.
I agree completely, Judge Levinci. So,
I think this court's held, I think opposing counsel is correct. The court has held that 2021 amendments can be applied retroactively. I think that's correct. I think that's still up for argument in the Michigan Supreme Court. I don't think they've addressed.
I think that's what Shaver said, essentially, that the 2011 amendments are.
2011
Right.
are, my understanding of what Shaver said was 2011 as applied to someone who was convicted before 2011 is an ex post facto punishment.
I meant to say 2021. I meant to say 2021. So that's my understanding of Shaver. I think what Mr. Lucas is seeking, I think, is a basically a declaratory statement that he can't, that the 20,
Wouldn't Mr.
11
Lucas still
amendments.
have to register under the rules of the pre-2011 amendments?
I think so. That was my understanding. They're 1994, they go back to 1994, 1995.
It's not like he'd get off the SORA. He would just have to comply with the pre-2011 and pre-2021 rules.
Yeah, correct. I mean, maybe there's some ambiguity with the 2021, but I don't, but.
I think the same.
Right. But no, correct. I think it's not a public registry, but right. I think that's how it worked. That's always been my understanding is that, of course, the SORA in place at the time he pled or was found guilty in 2007, I believe. So I think he would still have to register, but it wouldn't be the public registry. And there's a number of other things that wouldn't apply.
What, in the final page of page 17 of Chief Justice Kavanaugh's opinion, which is joined by all seven justices sign off on this case, it says, conclusion, quote, "We hold that Betts applies retroactively to defendants on collateral review under both federal and state retroactivity standards. Accordingly, we reverse the Court of Appeals decision, reversing the trial court's order granting defendants motion for relief from judgment, and remand this case for further proceedings consistent with this opinion. We do not retain jurisdiction." Okay, so the Supreme Court obviously is above us. We are the intermediate court of appeals for the trial courts. Should we be vacating this and even the other one and sending it back to the trial court? Say, address Shaver, remanded, let us know what happens.
I think that would be a.
We do not retain jurisdiction.
I think that'd be a perfectly fair and appropriate resolution of my case.
Right, no, and I know, and I really don't want any, either reviewing tribunal or, Lord forbid, a reviewing professional regulatory agency that all of us are subject to think that I asked Mr. Ambrose to comment on, ask anybody to comment on something that's not, Mr. Ferone to comment on Mr. Ambrose's case. That's not what I was asking.
No, I understand.
So
I understand that.
I just don't, I want to make the record clear for you so that nobody says, hey, wait a minute, he did something wrong. So
Well, appreciate it.
he's
Oh,
responding to my questions, which were inartfully stated.
No, I understood. That's all I have unless there's any, okay, I appreciate it.
All
Thank you.
right, you have time for rebuttal. All right, Ms. Mance, help us.
Kimberly Mans from the Kent County Prosecutor's Office, here today representing the people. As my predecessor Tim McMurrow would have said, it's clear as mud.
God, I miss Tim McMorrow. He's a
Yes.
brilliant lawyer and wonderful companion on life's journey.
When I thought about this case last night, I was initially thinking the same as you, Judge Redford, that, well, Schaefer came out, what are we to do? And then Audra Blodgett in our office was successful with People v. Shannon, which had an ex post facto component in it, in which it was the defendant that needs to show how he is facing more requirements now than he would have when he first registered.
And Shannon is case 37190, released for publication May 27th, 2026. So it's a very old case by comparison to Shaver, of course.
Yes. So part of the thinking is we have a case in which defendant, in this case, not Ottawa's case, but in this case, would have been subject to the 2006 amendment to SORA, which introduced the student safety zones, which was one
I
of
have a
our.
question.
Yes.
As I've read and reread Shaver
Yeah.
multiple times since yesterday morning, including, well, at any rate, I've read it a bunch, several times. And what is the people's position of what duties or obligations that existed before Shaver was released? So in the ancient old days of last Friday or last Wednesday, before Shaver's released, if a person was convicted in 94 of a registerable CSC offense,
Okay.
as well as 2006, like we have in Mr. Lucas's case, I think anyway, if they don't have a duty, let's say we don't have a 2011 requirement, or we say the 2011 is ex post facto punishment.
Correct.
Is there any other, did the 2011, the decisions that say 2011 is punishment,
Mhm.
does 2006 continue to apply, or does the language now consider Shaver that says we thought about partially allowing it, we thought about rewriting it, but we've decided that's a purely legislative function, we're not going to go there? I mean, does that mean that 2006 is gone, or all prior SORAs are gone?
I don't believe so, simply because, well, there is a case pending now in the Supreme Court who Katie Went from our office is involved in, along with the Attorney General. It's People versus Eddie Smith, docket number 168200.
Hold on a second.
And my understanding, limited as it is that a good portion of that is what remedy? Just what you were asking, what remedy? I know that Eric Restucia from the Attorney General.
Has leave been granted? Has the Supreme Court accepted the case?
Yes.
Okay.
Yes.
Do we have more arguments scheduled yet?
I know that the Attorney General was requesting oral argument in June. I don't know if that's been set. I believe Ms. Went is on today's schedule as well. She may have more current information.
Do you know, Mr. Ferron? Okay.
But I know that the Attorney General wants it as soon as possible, so he was requesting June argument. We don't know yet. But he has pointed out in his brief, for ex post facto, you have to, as a defendant, you have to say, I have to do more things now. This is greater requirements of me than when.
Right, and we spoke about that in Shannon.
Yes. And so if you do that, again, in this case, when he first registered, it would have been under the 2006 SORA.
Okay.
And now we have 2021 SORA. At the time that he registered, he would have still registered for life, which is the same in both versions. He would periodically, about 4 times a year, have to go in and report. 2006 imposed those student safety zones. And of course, 2021, part of what 2021 did was get rid of those. So in that vein, there's less requirements.
Right.
So that would be our continuing argument that,
But didn't Beth say we can't parse that?
pardon?
Beth said we can't parse those. I mean, I guess if someone else says something
Shannon
else
said
later,
yes.
well, but Shannon was a 2021.
No, Shannon was just now. That Shannon
No, it was a
last week.
2021 law.
Oh, right. Sorry.
Versus the 2011.
Yes.
Yes.
And
And
it happened. Okay.
Yeah. And here we're looking at 21 versus his more,
I'm told that oral argument is not scheduled
yeah.
on that brief. Yeah. Thank you.
I think they have 7 or 8 amicus briefs. So it's going to be
Sure.
a big case.
Should we, speaking of briefs and amicus, as opposed to just us issuing an order that says vacate, send back, or some lengthy opinion addressing substantively the 2 claims in the 2 cases, what value, if any, would there be from your perspective? And I'm going to ask Mr. Ferrone for his input too, to the court issuing a post-oral argument order saying we would like additional briefing on X, Y, and Z.
I would welcome that, especially with all of the changes coming up. I was going to suggest at the minimum, the court may want to hold it in abeyance until we have.
We get yelled at by
Really.
by the great computer in the sky if we hold cases too long. No, I'm just kidding. Well, I know this is a serious matter, but
Yes.
no, and I've been on a couple of panels where we've held an abeyance, and I mean that is also the 3rd possibility, I guess, out of 4 possibilities.
I really,
What would you like to? What if you were? And I'm going to ask Mr. Ferrone this too. If you were to receive an order from us about supplemental briefing, what questions would you like us to be asking you to address, other than Shannon, Shaver?
well, given the initial issues that defendant laid out in our case, their argument had the factual argument saying that it wasn't brought up at sentencing. I think I point out that it was in the pre-sentence report and he was asked whether he read that.
Right. I think I think that train left the station. I think Mr. Ferrone said, yeah, we understand that it was talked about, or I don't think we're still arguing that, are we, Mr. Ferrone, that he wasn't advised at sentencing?
It's not in the sense.
Okay.
The judge didn't state something specific about SORA during the sentencing hearing.
That was Judge Booth, right? I'm pretty sure it was. Anyway, it doesn't matter who the judge was, but
I would welcome the chance to do additional briefing, especially with how everything has changed recently. Obviously, we submitted briefs. I think mine was in early December.
it's been a long time.
Yeah, before
Yeah.
Schaefer or before
Right,
they
before a
decided.
lot of these, yeah.
So I would welcome that. You could also, again, hold it in abeyance, or as I believe you suggested before, you could remand it, asking for the court to look again at it under these new cases. Any of those opportunities would allow us to make further argument specific. So I am open to.
One thing a remand would do is it allowed development of the record some.
Right.
Which is often helpful when you're a corrective court. Okay.
Thank you.
Any other questions, Judge Wallace, for Ms. Mans? Judge Levency? Okay, thank you. Mr. Ferrone, the world's your oyster. You get to write the Court of Appeals order. What would it look like?
Well, I probably would be partial toward remanding it. see if we could sort it out there and maybe, I think that rather than, I mean, I'm not against that. I'm actually not against opposed to any of the suggestions that have been made. Further briefing here, not opposed to that, but probably on balance, under the circumstances, remanding, it would be, what I would prefer, just to make, for the circuit court to make further findings in light of these cases that have come out. I will say, the reference to SOAR, it's there in the judgment. It's line 3. Mr. Lucas and I were wrong about that. It's in the judgment sentence. It wasn't mentioned at sentencing. That, so the arguments are
Right.
still there regarding Nunez and, which was published, Kleinsmith, which wasn't. So there's still active arguments.
Okay. You're not abandoning that argument.
No, in fact, the court could, resolve the case by stating something similar to what was the way I read Nunez, that it wasn't mentioned at sentencing. This would be ideal for Mr. Lucas. It wasn't mentioned at sentencing, therefore the ship has sailed. It's too late to amend the judgment of sentence under the court rules, and it all goes away. SOAR registration, 1994 forward, goes away. That is Mr. Lucas's argument, or better said, that's what I've done with it. I gotta be honest, I'm not sure in his improper briefing, he mentioned that it wasn't mentioned at sentencing. He focused on the judgment, but he probably did. But that's been my argument, which is it wasn't mentioned at sentencing. So, in fairness, if you want to ask opposing counsel about that, I'm not going to object because she did start to talk about it, and so. But that is still an active argument. It wasn't
Okay.
mentioned at sentencing.
All right.
That's all I
Thank you.
have. Thank you.
Appreciate it, Mr.
Thank you.
Fromm.
Thank you.
Anything else, Mr.
Thank you.
Judge Wallace?
No.
There's nothing. Thank you.
Anything you want to add before we finish?
No, I would stick with, as to the first, issue, I would stick with what I read.
Okay. All right. These matters are submitted. Well, the case number 4, which Ms. Mans and Ms. Ferrone appeared on 369-485 is submitted. People versus Lucas also, but case 369-486, that is also submitted. Okay. Ready to keep going? Sure. All right. Next case is case number 5. I'm sorry, case number 6. It's the estate of Nancy Marguerite Torres versus Charles C. Sherry D.O. Mr. Broadus is here, defendant appellee. The appellant, Teresa Lynn Castro, is by order issued, I believe yesterday, is allowed to proceed in pro per and may appear in person. I don't know. Ma'am, are you here? Okay, Dan. Okay. Anybody from IT out there in the ether?
Your Honors, I've promoted her to panelist and she has declined both times. I will try again.
Okay, thank you.
Thank you.
While we're waiting, counsel, why don't you make your appearance?
Thank you. Drew Broadus for the defendant's appellees.
Great. Thank you, Mr. Broadus. Nice to see you. Okay. Ma'am, I'm Judge Redford. I'm the presiding judge at this panel's oral argument today for panel number 6 here. You're the appellant. I'm going to ask my colleagues if they have any questions. We have had a chance to review the record. We've reviewed all submissions made by you or anyone else on your behalf, as well as the submissions of defense. Could you please just state your name for me?
Teresa Lynn Castro, Your Honor.
Thank you, ma'am. Could you spell your last name for me, please?
Castro.
Thank you, Ms. Castro, and thank you for being with us here today. Judge Wallace or Judge Levency, any questions at this time for Ms. Castro? Judge Wallace indicated no. No. Okay. Ms. Castro, I don't have any questions right now. We'll give the opportunity to have Mr. Broadus, he preserved oral argument, so he'll be able to answer or provide argument And then I'll return to you to see if we have questions. Do you understand, ma'am?
Yes, I do, Your Honor. Thank you.
All right, thank you, ma'am. Counsel?
Your Honor, again, Drew Broadus for the defendants appellees. In my experience, the court had a lot of interest in one-sided oral arguments, so I'm not going to really elaborate. I'm just asking the court to affirm the summary disposition ruling in this medical malpractice action.
Okay.
And I'm happy to answer any questions.
And okay, thank you. Judge,
No.
Judge? No. Okay, there are no questions for Mr. Broadus. Ma'am, Ms. Castro, before we submit the matter, is there anything, and we have read it, we're sorry for your loss in this case. Is there anything you would like to briefly state before we submit the matter for our consideration?
Your Honor, I apologize for the last minute motion that I submitted yesterday. Our attorney that we had contacted the end of December decided to retire, and it left us in a very difficult position because we did not have counsel to continue. I did try to find counsel, but because it was so very last minute, I was not able to find anyone to help us with this for this hearing today or for this meeting today. And I apologize for that reason. As I told Mr. Beanon that was representing us, I am an interpreter, but I'm not an attorney.
Right.
And so I don't know, all of the right things to say or what to say and what not to say, because that's not my expertise as far as, being in the courtroom. I just wish that the court would hear our petition and be able to examine the evidence that has been submitted and to be able to send this case to a jury trial, and that the evidence would be able to be considered as valid evidence of medical malpractice. As you have, I'm sure, seen, there was staples used on my mom's knee for the knee surgery. And even after her medical records stating, for at least 10 years that my mom has a metal allergy, there still was metal staples used in my mom's knee. And so I would just respectfully ask the court to please consider my mom's case, and that we would be able to continue on to the next step, please, Your Honor.
Okay, thank you, Ms. Castro. The court has reviewed it. We've talked about your case as well as a number of the other cases beforehand, and we'll continue to talk about it as we try to reach our decision. And we understand the loss of a loved one or a parent is a difficult thing, of course, a very difficult thing. And but we'll address the facts and the law, and they'll make a decision. But thank you for appearing today, counsel, Mr. Broadus. Thank you for appearing on behalf of defendants. Ma'am, the matter will be submitted now. Thank you. Have a good day.
Thank you, Your Honor.
Yes, ma'am. All right. The next case is Marion Ipple versus Grace Christian Reformed Church, Grand Rapids, case 7 on our docket, 370. I'm sorry. Court of Appeals number 373022. There are a lot of plaintiffs and defendants endorsed. Mr. Carlson, it is nice to see you again. It's unusual for you not to be here with your group of 14 other lawyers on the same case. I hope you've been well. Yes, yeah, far better than my conduct or my modest talents deserve. So, but thank you. It's good to see you as always. All right. Okay, let's have appearances before we go into the oral argument. So ma'am. Thank you, ma'am. And then Mr. Carlson. Okay, Mr. Carlson, I had the privilege of serving him and his clients in a case for a long period of time. And now a very much more capable panel will be deciding how many mistakes I made. And so it'll be going from there. So anyway, counsel. Thank you, Mr. Portinga. Okay, thank you, Mr. May. All right, so on, each side has 30 minutes. You don't get 60 because you have two lawyers here. So if two people are going to argue, you all get to decide, but, I'll be keeping track of the time, and we'll, but that's how we're going to go. Ms. Canepa, you'll be presenting for the plaintiffs. Please proceed.
Good morning, Your Honors.
Morning.
I'm happy to answer any questions this morning. As you know, we're here on appeal of a grant of motion for summary disposition under C7. But the core of our appeal is as follows. Marion Ippel's claim is timely because in 2018, the Michigan legislature extended the grace period for minor victims of criminal sexual assault from age 19 to age 28. The core dispute, I think, before the court today is which grace period applies for Ms. Ippel. The age 19 grace period that existed prior to 2018 or the age 28 grace period that existed as a result of the 2018 reform under MCL 600-5851B. Under Michigan law, an extension to the statute of limitations applies to existing claims that are not yet expired. There are a number of cases in support of this, including Russo, which we cited in our brief to you all, as well as Hansen-Snyder, which is a 1963 Michigan Supreme Court case on a civil matter. Defendants have not cited a case, and I am not aware of any case contrary to the principle that an extension to the statute of limitations applies to an existing claim that has not yet expired. In this case, Ms. Ippel was age 15 at the time that the Michigan legislature adopted the 2018 amendment. That means that she was still a minor and her claim was still timely under the prior legal scheme. The prior law governing was Section 5805. That's the default 3-year statute of limitations for personal injury, with the 1-year grace period of Section 5851. That takes a minor to age 19. However, in 2018, as you all know, the Michigan legislature adopted the amendment to that framework under 5851B. I'll read to you the text of the new statute. So 5851B, the new 2018 law, provides in subsection 1, notwithstanding 5805 and 5851, which are the two sites I just read to you a moment ago, the controlling law for Ms. Ippel prior to the amendment. An individual who, while a minor, is the victim of criminal sexual conduct may commence an action to recover damages sustained because of that conduct at any time before whichever of the following is later. Subsection A, when the individual reaches the age of 28 years. Subsection B, 3 years after the date the individual discovers that claim. Paraphrasing on that last sentence there. In this case, on the plain language of the 2018 law, Ms. Ippel's claim is timely under subsection 1A because she filed her suit before she reached the age of 28. We're here on appeal because the trial court erred when it dismissed this action as untimely as a matter of law. As I just stated, Ms. Ippel's claim is timely on the plain language of the new 2018 law under subsection 1A. The trial court made a number of errors. First, the trial court erred by conflating subsection A, which is the age 28 extension, and subsection B, which is the 3-year discovery rule. These are two alternative ways of establishing a timely claim under the 2018 law. To read them as a single test, as the trial court did here mistakenly, would render the text of the statute meaningless where the text of the statute provides whichever of the following is later and then lists the two grounds for a timely claim. The trial court did not address 1A at all in its reasoning, even though Ms. Ippel briefed both grounds of timeliness at the trial court level. Ms. Ippel had raised both 1A and 1B, but the trial court only addressed 1B in its reasoning. The hearing transcript.
Would her claim be timely under 1B?
Excuse me?
Would her claim be timely under 1B?
It would not be timely under 1B,
Okay.
Your Honor. The hearing transcript for the trial court it's page 23, where the court discusses its reasoning in granting the motion for summary disposition. As I said, the trial court did not discuss 1A at all. It focused exclusively on 1B, and it was a mistake by the trial court to disregard the plaintiff's argument under 1A. The trial court also erred by relying on the Michigan Supreme Court decision McLean for several reasons. First, McLean addressed a different subsection of the 2018 law. McLean exclusively addressed 1B. McLean did not address 1A. McLean also addressed very different facts.
But didn't McLean talk about which statute of limitations controls? As specifically, didn't they speak to the statute of limitations, which is in effect when the cause of action accrues, is the statute of limitations that controls? Didn't McLean speak to that?
McLean does speak to those general principles of accrual. However, in this case, Your Honor, the accrual analysis actually does not change which grace period applies. The grace period is really the key issue for the court's consideration. So even assuming that Ms. Ippel's claim did accrue at the time of the assaults when she was a very young child, the grace period, even under the old regime, would have been until age 19. And because that had not yet expired as of the date of the 2018 law, extending that grace period for minors, that new extension applied to her claims and extended them to age 28. So I want to emphasize just briefly the factual differences between McLean and Ippel, in case that is helpful to the court. Mr. McLean was abused at the age of 16, and his claims expired in 2002, almost 20 years before the 2018 law and over 20 years before he filed suit. Because his claim was already expired at the time of the 2018 amendment, the changes under the 2018 law were not available to him, as McLean acknowledged with respect to 1B. But McLean could not rely on 1A, and he did not rely on 1A, the 28th birthday provision, because he was already 35 years old when the 2018 law went into effect. So subsection A was not before the court in McLean. And in contrast, here, Ms. Ippel does not rely on the discovery rule for her timeliness here. Her rights continue to be live at all times. As of the 2018 law, her claims were still timely, and the defendants had not yet acquired a vested right to assert the statute of limitations. That's dramatically different from McLean. In McLean, the defendants had had a vested right to the statute of limitations, as I said, for nearly 20 years.
Do you have is it possible for you to tell the court when this amended statute takes effect, who gets to take advantage of the individual reaches the age of 28 language? I mean, when does the offense or actions giving rise to the claim, when would they have had to take place? I've tried to sort of imagine it in my head, and I don't know if I having heard your co-counsel's arguments for 2.5 years, he has a brilliant and creative mind. I imagine you guys have probably talked about this. Is there a time period that you can tell me?
Your Honor, as long as a plaintiff satisfies the plain language of 1A and files by their 28th birthday, they have satisfied the standard as set out by the statute. And so to answer your question, I think that could go back as far factually as one could while still meeting that deadline. So it could be a very early claim. It could be abuse for a very young child, but as long as the plaintiff ultimately files by that 28th birthday, they are still within the ambit of that provision. And I would say, as long as their claim had not yet expired as of 2018 when the law went into effect.
Okay. I've just been trying to sort of imagine what ages a person would have to be and when would the conduct have to take place for the defendant's argument to be meritorious? And if the defendant's argument is meritorious, how much time has to expire before a plaintiff can get the benefit of this? And I don't mean benefit in a pejorative way, but take it, use this statute to continue to be able to pursue a claim that they say I'm entitled to bring. I mean, when does this provide any benefit if their position is correct?
When does 1A provide certainty for plaintiffs? Is that what you're asking?
No, it's not. I'm not articulating it very well, but it just seems if the defendants are correct, oh no, the statute of limitations, which is in place at the time of the facts giving rise to your claim, is that which governs. Doesn't matter if the legislature changes it. It's what was in action, in whenever. So if this statute is enacted in 2018, if misconduct took place in 2017, then as I understand it, the defendants would be saying the person who's injured in 2017 or makes a claim based on conduct from 2017, you have until your 19th birthday to make this claim because you can't use this amended statute of limitations. Is that your understanding what the effect would be of their argument?
That is my understanding of defendant's argument, and our position is that would be mistaken because that person who was assaulted in 2017 would still have had a live claim as of 2018, and under Michigan law, when a statute of limitations is extended, that extension applies to all existing
So let's say
non-expired
it's a
claims.
10-year-old is assaulted, wants to make a claim. 10-year-old in 2017 is assaulted. If the defense's position is meritorious, then 9 years later, in 2029, they have to bring the claim. Even though the legislature said in 2018, you have until you're 28, which would have given them until 2036 or 37. They'd have had 9 more years.
Let me make sure I follow the hypothetical. This is in a situation where a 10-year-old is assaulted in 2017.
Yep. Yes.
So they would be 19 years old in 2026. If my math is right.
Yes.
And so
2016, or 2017.
Thank you, Your Honor.
2017, yeah.
and so you're asking,
My hypothetical confused me so much. I can't remember.
well, we've gone over a whole lot of hypotheticals to make sure that we have a mastery of this law too, and it is definitely can be circular at times. So in your hypothetical, yes, the 2018 statute would apply to that 10-year-old because the 10-year-old, as of the passage of the 2018 amendment, was still a minor and their claim had not yet expired as of 2018.
Right. The question is, if the defendant's position is right, if
I understand. You're asking if the defendant's position is right, wouldn't that 10-year-old be held to the prior standard, which would have given them 3 years or up till age 19. So they would have had until 2026. I'm sorry, but the 10-year-old would have had until age 28 under the new law.
Okay, thank you.
I'm happy to answer questions. Otherwise, I would reserve 5 minutes for rebuttal.
Okay, thank you, counsel. You have not enough time.
Good morning, Your Honors. I'd like to start addressing your hypothetical, Judge Redford, if I may. And I think we're on the same page here, which is that for any alleged assault that occurred before the date of the amendment, we would look to the pre-amendment statute. And the basis for that is what the court said in McLean. Both the majority and on page 8 of the slip opinion and Judge Zara's concurrence said the anchor point for the application of the statute of limitations is the date of accrual. And for pre-18 alleged abuse, the date of accrual is the date of the alleged abuse. So for example, Judge Redford, in this case, we have a plaintiff who alleges abuse in 2006, 2007 at the age as a minor. She had either 3 years until the age of 19. She turned 19 in 2021, and it is at that point that her claim expired. We have here, Your Honors, a situation where we have a very recent and on point decision, unanimous from the Michigan Supreme Court. That is the McLean decision. And the two key holdings from that decision are one.
Isn't that a discovery rule decision?
So McLean does focus on paragraph B, which is the discovery
This
rule.
isn't a discovery rule case. I mean, I'm staring right now at People v. Russo. Michigan Supreme Court binding precedent that says there is no vested right in the running of a statute of limitation except when it has completely run and the action is barred. So when this law goes into effect in 2015, it hadn't run, it wasn't barred. And so you're essentially arguing that your client had a vested right at that point in time, even though People v. Russo says your client did not.
Judge Wallace, we are not arguing that we had a vested right. There's a distinction between what the legislature can do and what the legislature did do. We are not arguing, Judge Wallace, that the legislature is prohibited from extending the statute of limitations on a retroactive basis. The question is, what did the legislature do here? And that question was answered in McLean. And yes, it is true.
Again,
But
McLean's a
McLean-
discovery case.
Well, and whether it's a discovery case or it's a case of, constitutional interpretation, the plaintiff in McLean, if the statute had not been enacted, McLean never would have been able to bring a claim, period. This plaintiff, the day the statute was enacted, still had 3 more years to bring the claim. And the legislature said, hey, if you have a claim, you could bring it, whichever the following is later, the individual reaches the age of 28. I am having trouble connecting the dots with your argument.
Let me do
Not
the
as
best- let me do the best I
eloquently
can.
stated as my colleague, but
Well, let's start with the fundamental premise of McLean, which is that in terms of statute of limitations and statutes generally, they are presumed to be prospective only unless there's clear legislative intent or retroactivity. In McLean, the court said, and I
why do you
acknowledge-
think this is retroactive?
I'm sorry?
How is this retroactive?
Because McLean says that the anchor point, this is on page 8 of the slip opinion, the anchor point of the statute of limitations analysis is the date of accrual. So step number 1 is, when did the claim accrue? Okay, we know pre-2018, the claim accrued at the date of the alleged abuse. All 7 justices in McLean agreed on that. There was a new accrual rule created in 2018 as part of the amendment, but McLean says that only applies prospectively. We get back to the question of what did the legislature intend to do in 2018? And what this recording from McLean said was this was intended to be prospective only. Why? Because that's the presumption. The presumption is only overcome by clear legislative intent. And what did the court in McLean do? They looked at 3 things in terms of the 2018 amendment. They looked at the text, they looked at the structure, and they looked at the legislative history. In the text, they said, well, is there anything in the text of 5851B that explicitly makes it retroactive? The answer is no. That was true for subsection B. It's true for subsection A as well. And regarding the
It says, counsel, it says notwithstanding 5805. Poor Mr. Carson knows this. I have the printed books. So 5805, injuries to person or property. So our legislature in 2018 says, regardless of what we said about injuries to persons or property in 5805, this is what the law of Michigan is now. How does,
On
how
a
is that,
prospective
is not
basis.
a, I don't see the words as a prospective measure to give plaintiffs a right to bring claims. It doesn't say that, counsel.
It's because, Judge Redford, the presumption is prospective, and that presumption can only be overcome by clear legislative intent. And I just add, Your Honor.
How about at any time? Look, so
If I
while
may,
a minor is the victim of criminal sexual conduct, may commence an action to recover damages sustained because of the criminal sexual conduct at any time before whichever of the following is later. A, the individual reached the age of 28. B, 3 years after the discovery rule, 3 years after the discovery or when they reasonably should have known by the exercise of reasonable diligence.
and Judge Redford, that applies to any abuse that occurs after the date of the amendment. And let me, if I may.
It doesn't say that.
It does, Your Honor. Because
Where?
look at McLean. Look at what McLean says.
No, where, I want to read the law, okay? I'm just sort of old fashioned that way.
Yeah.
I want to apply the law, whether I like the laws or I don't like the laws. It's my duty to say, here's what I believe the law says.
Well, let's look at paragraph 3 of 5851B. 5851B, paragraph 3 is a retroactivity provision. It's a carve out that applies, it was narrowly drafted to apply to the victims of Larry Nassar.
Counsel, yes, it says we're giving you 90 days. It's a revitalization of claims when there's a CSC criminal conviction, right?
It was the Larry Nassar class of victims is what it was.
I don't see Larry Nassar's name anywhere.
Nassar's not in there, but that's the context. Yeah.
Okay, but again, we do agree it's not in the law. It doesn't say that.
Larry Nassar's not in the statute, correct?
But they wanted to make sure, regardless of any period of limitation under subsection 1 or sections 5805 or 5851, an individual who, while a minor, was a victim of criminal sexual conduct after December 31st, 1996, but before 2 years before the effective date of the Amendatory Act that added this section, may commence an action to recover damages sustained because of the criminal sexual conduct within 90 days after the effective date of the Amendatory Act that added this section if the person alleged to have committed the criminal sexual conduct was convicted of criminal sexual conduct against any person under section 520B of the Michigan Penal Code of 1931, and the defendant admitted either of the following: A, that the defendant was in a position of authority over the victim as the victim's physician and used that authority to coerce the victim to submit, or B, that the defendant had engaged in purported medical treatment or examination of the victim in a manner that is or for purposes that are medically recognized as unethical or unacceptable. That's section 3.
Judge Redford, if the legislature had intended all of 5851B to apply to all claims, no matter the date of the accrual, there would have been no point to have paragraph 3.
But don't we have to assume the legislature was aware of People v. Russo?
Yeah, and I'd like to talk about people reverse because that addresses the question of what the legislature can do versus what they did do. And we are not, Judge Wallace, arguing that there's a vested right here. We're not arguing that there's a constitutional prohibition. The question that the court has to answer, and the question that was answered by McLean unanimously, is in passing the statute in 2018, the legislature did not intend that statute to apply to pre-2018 abuse. And I would direct the court to footnote 19.
Except only if those claims, I mean, in McLean, they applied that when the person's claim had expired, had been extinguished.
McLean's claim had extinguished.
Right.
That is true. That is a factual distinction. Yes. But again, if you look at the rationale behind that reasoning, the rationale applies equally regardless of the date, because we look to the date of accrual to determine what law applies.
Well, let me ask you this. Pretty familiar hypothetical here. Criminal sexual conduct occurs. We can agree the claim accrues, right?
Yep.
That would include both civil claims as well as criminal claims, right?
Correct. Yeah.
All right. Statute of limitations, there's at the time. And then there's a change in the statute of limitations while that claim is still ongoing and still viable. And then if a case is brought after that prior statute of limitation had expired, but before the amended one applies, you're saying that's not okay.
I'm saying you apply the law as it existed at the time of the assault.
But that's exactly the opposite is what happened in the, I'm going to say it wrong, the Cheesebro case.
And Russo too.
Well, and Russo, but Cheesebro is also a criminal sexual conduct case.
And Cheesebro is also a criminal case, not a civil case.
That's true.
Yeah.
So if a new statute of limitations applies when the issues of someone's liberty and going to prison is at stake,
Yeah.
that's okay.
No,
But a civil case is
Yeah,
not.
yeah,
No,
I mean,
no.
riddle me that one,
But
Batman.
again,
Yeah.
Judge Levinson,
Exactly.
with all respect, I think you're confusing the question of what the legislature can do versus what they did do. And Cheesebro addresses the what they can do question. It also says, it reads that statute as applying retroactively. There's not much of analysis. There's no LaFontaine
Well,
analysis.
that gets
of
to whether LaFontaine is a workable standard, but unfortunately we can't address that.
That's above your pay grade, Your Honor.
I think you ought to be arguing about the date that Cheeseboro was issued.
I'm sorry, say that again.
I said, I think you ought to be arguing about the date Cheeseboro was issued, which was almost exactly 2 months before November 11th, 1990, which has a significant, which is very significant to this court, I think,
Okay. Well,
which is when, the
Right.
cases became binding
sure,
precedent.
I understand that. I understand, Judge Wallace. But I would just ask the court, I mean, I would direct the court to footnote 19 of the majority opinion, which addresses the legislative history of the 2018 amendments and said, the initial bill had a full retroactivity provision in it. That didn't pass. They had a very narrow retroactivity provision that whether the words Larry Nassar are in there or not, that's what drove the whole thing. And there's one other thing that I want to point the court to before I yield my time, which is that after McLean, there have been 2 bills introduced in the legislature.
What, sorry?
After McLean, there have been 2 bills introduced into the legislature that would have legislatively overruled McLean. That is, there have been 2 legislative attempts to overrule McLean. And of course, the legislature can do this because it's not a constitutional issue. It's not about vested rights. It's not about what the legislature can do. It's about what they did do. And both of those bills have failed. Well, pardon me. One bill failed in the 2014 legislature. The other one is still pending. So basically what the appellant is asking this court to do is to adopt a rule that the legislature has not adopted. A rule that the legislature has considered but declined to adopt. And frankly, Your Honors, that's just simply not an appropriate role for this court.
It's also not what she's arguing because this is not a discovery case.
This is not a 1B case. I agree with that. It's a 1A case. And the question is whether that was intended to be retroactive or not. That's right.
I think you have a super persuasive argument if the statute, like in McLean, had already expired. But you've got a plaintiff who had 3 more years before the statute passed to bring the cause of action. And then the legislature said at 2 years and 20 months, or 2 years and 10 months, the legislature says, oh, you have until you're 28.
And so my rhetorical question to you, Judge Redford, is if 1A applies to the plaintiff here, okay, how do you reconcile that with the statement on page 8 of the slip opinion, the majority, that says the anchor point of the statute of limitations analysis is the date of accrual? And how do you reconcile that with MCL 600-5869 that says with regards to the limitations that the law in existence at the time of the accrual applies?
Right. Well,
so you got to look at
when the legislature says, quote, notwithstanding sections 5805 and 5851 ... close quote, then I don't know. That seems like a reasonably sound answer.
But Judge Redford, it doesn't say notwithstanding 600-5869, which is the accrual rule. And I frankly, with all respect, Your Honor, I think that your analysis would be directly inconsistent with what the Supreme
Sorry,
Court
please.
said. I think that your analysis would be inconsistent with what the Supreme Court said in McLean. I don't think you can reconcile those two approaches.
Well,
But unless there's any more questions, I will yield my time. Thank you.
okay,
Oh, but well done. Thank you.
thanks.
I'll be quick. Probably not as quick as I was in the trial court. I want to try and clarify that in McLean, the court focused on the use of the word is rather than was in determining that there was no indication of retroactivity. And the word is contained in paragraph 1. It is not in sub A or sub B. It is leading into both of those sub paragraphs. So the analysis in McLean applies to the entirety of the statute, not just sub B. And they cite on, as Mr. Portinga pointed out on page 8 of the slip opinion, that statutes are intended to apply prospectively absent a clear legislative intent on the contrary. And then the court determined that there was no clear legislative intent in this statute. And they focused on this, Your Honor, Judge Redford, you indicated notwithstanding subsections 5805 and 5811 ... except that after the ... is the word is instead of was. So while a minor is the victim of criminal sexual conduct, gives the indication that it's moving forward. Doesn't say was the victim of sexual misconduct. And that is what McLean focused on. And that is what the judge focused on in this case when granting summary disposition, is that term and the legislative history. Now, you know, we've dealt with retroactivity on other issues in the last few years. I do a lot of no fault work. We had Andari and the other things that came from there. And so this issue of retroactivity is not a unique concept to this statute. It's something that the courts have addressed a number of times over the last few years. And it's always been the intent and the interpretation by the Supreme Court that if the legislature did not specifically enact this retroactively, that it's only prospective. And if we use the accrual statutes, which are not limited in paragraph 1, accrual occurred back in 2006 or 2007. It started, it went 3 years. The age 19 is similar to 5851. It is a extension statute. It's not a accrual statute.
Then why can't the legislature extend it to 28 or 128?
Well, they can, but they still have to make it retroactive and use the term was, or say it's retroactive from anyone that's had this issue. They use the term is, and the Supreme Court decided is means from June of 2028 forward, not going back. They don't just address the fact that Mr. McLean's claim wouldn't be saved by either part of the statute. What they do is they say his claim isn't saved, but we're also interpreting that this statute specifically is not intended to be applied retroactively. And that was the reason, as Mr. Portinga pointed out, that there was the 90-day grace period that extended it back and did make it retroactive for that 90-day period. They very easily could have said, we don't need that retroactive 90-day period because the whole statute's retroactive. And that's not the position that the legislature took, and it's not the way that the McLean court interpreted this statute. I don't think they limited their opinion about retroactivity just to sub B. I think it was based on paragraph 1 and included both subparts A and B. Said I try and make it short, so.
Okay, Judge Wallace.
No additional questions. Thank you.
Thank you.
Just briefly, a few additional points. Um, Opposing counsel raised a couple of points about the text of 5851B, specifically the use of the word is in the text. First thing to note there is that the 2018 statute is not defined by the date of the abuse so much as the claimant's status as being an individual who, while a minor, is the victim of criminal sexual conduct. And so in Ippel's case, Miss Ippel, as of 2018, is the victim of criminal sexual conduct. Additionally, in McLean, the court was really only asking the past tense question under 1B, which is when did Mr. McLean discover his abuse in the past, as opposed to whether or not he met the requirements under 1A. One additional thing I wanted to note for the court is in the course of preparing for arguments today, we came across an authority from 1963 in the Michigan Supreme Court that we had not cited in our briefing to the court, and that's Hansen Snyder versus GM 371 Mich 480. In that case, that is a civil case where the court held that claims based on pre-amendment facts were timely, where plaintiffs filed in accordance with the new extended statute of limitations. So for just a little bit of
What
context.
case is that, please?
Hansen Snyder. And that's 371 Mich 480. In that case, involved the legislature extended the statute of limitations for a worker's lien from 60 days notice of intent to 90 days notice of intent. And in that case, the claimants seeking the worker's lien had begun their work prior to the amendment. So the facts giving rise to the claim occurred prior to the amendment. And then they filed their notice of intent in accordance with the new extended statute of limitations. And the court, so essentially analogous facts to what happened here. And the Supreme Court ruled that those claims based on the pre-amendment facts were indeed timely because they had satisfied the new extended statute, and the extension applied to them because their claims were still timely when the amendment was adopted. The last thing I would note for the court, Section 3 of 5851B, the carve out for criminal convictions of criminal sexual assault. This provision is essentially meaningless for Ms. Ippel because she was covered by Section 1. Additionally,
Right, but what about the argument, as I understand it from defense, of, hey, listen, when they wanted to make it, we're covering everything. They specifically said it. Since they didn't, it doesn't apply.
So
I think that's, to me, is the more salient question.
So the use of a temporal restriction in Section 3 suggests that, or shows that the legislature knew how to create a temporal restriction if they wanted to do so, and they chose not to under Section 1. Under Section 1, the only requirement is that the individual files by the age of 28 years, and they did not impose any additional temporal requirement for that section.
I'm not going to ask you to do that. It's not calculus, but the algebraic questions I was asking before, I was trying to figure that out as relates to Section 3, and I don't think I even understand them yet. So since I don't understand my own question, I'm not going to ask it of you. You're welcome.
Unless you have any further questions.
All right. No, thank you both. Appreciate the briefing by both sides and the argument. It was very helpful. Mr. Carlson, nice to see you again. Safe journeys back. Okay, this matter is submitted. I would kind of like to get this next one done and then take a break. Is that okay? All right. So, okay.
Yeah.
All right. Thank you. Court calls the next matter, number 8 on our 10 o'clock docket. In Ray Hughes Estate, the appellant. Both sides are endorsed for oral argument, and both are remote. Mr. Thomas E. Dunn, pro per, is the appellant. All right. and Mr. Nickerson appears on behalf of the appellee.
Correct. Good morning, Your Honors.
Morning, sir. How are you today, Mr. Nickerson?
Very fine, thank you.
Good, nice to see you, sir. Is Mr. Dunn available? Anybody from IT? Anyone from the court's IT department on monitoring us?
Hi there, I'm getting it started. He
Thank
had
you.
declined, so it should be just a moment.
Okay. Mr. Dunn, your microphone is on mute. Cannot hear anything you're saying, sir. Cannot hear, Mr. Dunn, there's some way for your terminal to be unmuted. I cannot, nobody can hear what you're saying. Okay, try now, Mr. Dunn. I can hear you now. Go ahead,
Okay.
please.
I apologize, Your Honor.
Okay, you may proceed.
Am I going first? Am I going first? Your
Yeah,
Honor?
you're going first. Yes, Mr. Dunn.
Okay, thank you very much, Your Honors. Appreciate your time. We had, I would like to make note for the record that Mr. David Gilbert is no longer practicing law at this time due to medical problems. I've been involved in this case since the beginning with Mr. Gilbert. There was a brief supplied in support for appointment of personal representative as named in the last will and testament of Robert Hughes. And I was named as in that will, which was presented as the personal representative during the pendency of the probate court hearings. I would like to note that there was never an objection to the fact that there was a last will and testament, and that the last will and testament was in my possession in our home, and it was burned, and we had a copy of that in our electronic files. So I did have an original copy of that.
And my understanding is that the trial court rejected that and did not accept that document for probate. Is that correct?
That is correct, Your Honor.
Okay. Why do you believe the court was clearly erroneous or was erroneous in making that decision? Because my understanding is Mr. Gilbert testified and he said, this is not a document that I drafted. And you or someone else testified and said, this is a document Mr. Gilbert drafted. Since the attorney who was alleged to have drafted the document affirmatively stated to the court, I didn't draft this. Why was it an error of fact or law for the trial court to reject the proffered will?
The will that I had in my possession was from Gilbert Law.
He said it wasn't, correct? Do you agree that he testified it was not?
I do agree that he did say that, Your Honor.
Okay, so why was the decision that the trial court made in error?
Because it was signed by Mr. Hughes. It was his signature. It was his last will and testament. I had known Mr. Hughes for many years. I worked with Mr. Gilbert and Mr. Hughes on the sale of property that was left to him and his sister at his mother's passing. Mr. Hughes wanted nothing to do with his sister. And that was some documents that were presented, I believe, with the brief. And I'd known Mr. Hughes for a long time. I knew what he wanted. He wanted to make sure that his son and the VFW were compensated. And in the just recently, with as of 5/14, I had reviewed documents that had been submitted to the court. And that document that was submitted to the court was amended inventory of the decedent. And as I reviewed that document, I noticed many situations that were erroneous, and knowingly inaccurate documents in an estate can be considered a fraudulent act. Fraud typically involves an intentional deception for the purpose
No,
of financial
Mr.
or
Dunn,
personal
Mr.
gain.
Dunn, that's not before us right now. My question for you is, why did you not bring either of the people who are alleged to have witnessed this will? Why didn't you bring either one of them to the hearing to testify?
They were there, Your Honor.
Well, why didn't you take testimony from them?
I don't know. That was up to Mr. Gilbert. I testified to exactly what I knew and what I had in my possession at the time of his death, and that's the will that was presented.
Thank you. I appreciate that.
Okay. And questions?
No questions.
Anything else you want to share with us, Mr. Dunn?
Yes, Your Honor, is that this may not be before the court, but the amended inventory.
If it's not, Mr. Dunn, we are what is called an error correcting court. And the parties, our arguments and our decisions are restricted to the record of the court below. And if a party wishes to expand the record, they need to bring a motion. The other side has an opportunity to respond, and the court will rule on it. Since you have done none of those things, or I don't believe you've made a motion to expand the record, I'm not going to allow you to argue about things that you believe happened below that are not part of the actual record of the trial court. I don't mean to be discourteous, but we are not able to fulfill our statutory duty as a error correcting court if the trial court hasn't in the first place had the opportunity to address the issue. Do you understand what I said?
Basically, I do, Your Honor.
Okay.
Yes.
Is there anything else related to the record or your brief that you'd like to share with the court before we ask Mr. Nickerson if he has any questions or anything he'd like to share?
Yes, I believe that under MCR 5.132 that states that there was no written objections by Mr. Nickerson at the time. And we believe that the will should stand as it was originally presented to the court.
Okay. Thank you, sir. All right. You have time for rebuttal. Mr. Dickerson, what would you like to bring to the court's attention?
Thank you, Your Honors, for allowing me to appear by Zoom. I appreciate the accommodation very much.
Yes, sir.
Thank you. First, I'd like to point out in their brief under argument at paragraph A, they say the petitioner, appellee, Hughes knew that there was a last will and testament, and that's blatantly false, Your Honor. Miss Hughes searched the home of Robert Hughes, and it was a mess. They even admit that he was a hoarder. She searched and searched thoroughly and could not find a will. So them stating that she knew there was a will is blatantly false. The second thing about what they file is that argument I, they state that Ms. Hughes presented no testimony. I'm sorry, that's G, paragraph G. That she gave no testimony on the original will. How could she give testimony on something that she knew there was no existence? The argument that is being presented by the appellant apparently is that the judge sua sponte recognized a point of law that there's a presumption. So they don't challenge that, but what they're challenging is apparently the fact that the judge should never have brought that up. On sua sponte authority, the only case that I could find that is applicable is a case called El Malika versus LeGrand, case 286 Mishap 483. And that court interestingly links the court's application of sua sponte authority to due process. And it says there, if something is raised, if the court raises an issue, the litigant must have an opportunity to address that issue in a hearing. And in this case, the appellant had an opportunity to be heard, a meaningful opportunity to be heard. The judge opened the record, and it was based on the record that the judge found a lack of credibility. And so for those reasons, we think that the petition should be denied and that the order by Judge Klaus should stand.
All right. Thank you. Any questions for Mr. Nickerson, Judge Wallace?
No, thank you.
Judge Levency?
No, thank you.
Okay. Thank you, counsel. Appreciate your being with us. Mr. Dunn, any final comments before we submit the case?
Thank you, Your Honors, for listening to this. The one thing that being in investigations along with Mr. Gilbert for many years is that it looks as if the court will not entertain if there is fraud on the court for falsification of documents. And I think that the court should put this under, if it goes back, is to have this case under supervision, and all the documents, all the figures that are being submitted in this case be supervised and taken a look at, because they are definitely underestimated in several areas by thousands of dollars.
Your Honor, I have to take exception to Mr. Dunn's statement that the inventory has been misrepresented. I know it's not before the court, but I just can't let that stand.
I understand. That's Mr. Dunn, any judicial officer takes very seriously allegations of misrepresentation, of fraud upon the court. The judges of this court, we've done our due diligence, and that which you speak of, at least, and I don't presume to speak for my colleagues, they're brilliant jurists, but I don't see anything in the record which suggests that which you speak of. But that is not an issue which is briefed. We're not going to go into a lengthy discussion about that, but the matter is submitted. Thank you both. That concludes the 10 o'clock docket of our court. We're going to be in recess momentarily. I want to ask a question about the next case. Number 9 involves Sheffield versus Chippewa. Number 12 involves Armour versus Kalamazoo County. Mr. Visser is endorsed on both. Mr. Curlew is endorsed on both. And there is a Mr. Vanderlaan also endorsed. Is Mr. Vanderlaan here? Okay, so your Curlew's here for both. Is Mr. Vanderlaan here? Okay, then do either of you object, Mr. Visser or Mr. Curlew? The correct answer to this is going to be, I don't have any objections, but just so you know, any objections to, since you have the first and the last cases on our afternoon docket, I would like to call yours at the end so other counsel can present their matters. That'd be Gordon versus Gordon and then Campbell versus Campbell. Do you mind if we address those two cases first and then your two cases? Is that all right with you, Mr. Visser?
Thank you for the
Okay. Mr. Curlew, do you also wisely agree with your brother counsel? Oh, my God, no. Oh, no, no. All right. So next on the docket is going to be number 10, followed by number 11, followed by 9 and 12. Courts in recess on how much? 10 minutes? We'll recess until 25 after 12. Thank you. Panel 6, Court of Appeals of the State of Michigan, Panel 6, back in session. First case is Gordon versus Gordon. And it's not. Let me get the right folder. Sorry. Speaker, are you here for this one or? Okay. All right. And yes, I'm sorry, Ms. Schmidt, thank you. Both Ms. Schmidt and Ms. Gordon are endorsed for remote. All right, counsel, you may proceed.
Yes, Your Honor. Did you say that? Ah, there she is. I was going to say, did you say Ms. Gordon is endorsed? Because I would wait until she was ready.
She's not endorsed. She's appearing so that we can ask questions if we require it.
Okay.
I understand.
Not a problem.
All right. Okay. All right. So please proceed.
Of course. And I know this panel's preference when it comes to one-sided oral argument, so I will keep us very short unless the panel has questions. Judge Redford, earlier this morning, you said that you wanted to look at the law, and that's what I'm asking you to do here. The theme in this case is the enforcement of stare decisis, which for Ms. Gordon's benefit is that new court decisions are controlled by cases that came before, and by the statutory protections for children when they make expressions of risk of domestic violence or child abuse. Very briefly, what we're asking what a parent is to do when his preteen and teenage children refuse parenting time based on safety concerns that they can't explain. The trial court committed multiple clear legal errors, failing to follow a stare decisis, determining that the children had an established custodial environment with their estranged parent based on their pre-separation relationship, and modifying the entire custody arrangement based on parenting denials with nothing more, and allowing a referee to use the child's interviews to investigate the substantive issue of the basis for their safety concerns rather than their reasonable preference. Because of this, we ask that the court vacate the trial court's decision and remand for dismissal of the mother's motion due to a lack of proper cause or change of circumstances. Does the court have any questions for me?
Judge Wallace? No. Judge Levent,
I do. It's my understanding of the facts. There was a stipulation regarding parenting time in 2024 that expired in December of 2024. Is that correct?
That is correct, Your Honor. It was a very short period of stipulated order to get them into some reunification therapy. Unfortunately, only 2 sessions happened before that period expired.
My follow-up questions are, after that, what was the governing parenting time relationship or situation?
So
once the stipulation expired?
Sure. After the stipulation expired, and it was pretty clearly argued in the trial court, they went through this rather extensively. The court was convinced that the existing week-on, week-off arrangement, the unspecified week-on, week-off arrangement from the consent judgment went back into place. My client's perspective and argument was that because reunification was ongoing at that time, that the reunification therapist should have been able to direct what was in the best interest of the children, and that initial order was simply to get the ball rolling, to get them into a therapeutic environment where the therapist could make those recommendations.
So you've kind of answered my question by saying it was my client's position that essentially while you acknowledge that after the stipulation expired, there was this week on, week off, your client didn't follow that, right?
That is accurate. Or I should say that it is accurate that the children did not go to mother week on, week off. We went back to the situation where he would tell them to go with their mother and they would refuse. And so he would end up back at the school to pick them up. Do I wish that he had been more aggressive? Sure. Do I think that there is, I'm sorry.
Why would he do that in the first place? If it's her day to pick up the children, why would he appear at the school?
There's a relatively lengthy quote in the brief, Your Honor, where he explains that every morning the children would pin him down and
Yeah,
demand
but he's
that-
the parent. He's not one of the children. And
I
he knows
understand, Your Honor.
he knows there's court orders in effect. Isn't he just encouraging them to encourage himself to violate the order?
Or is he in fact exercising reasonable caution under 722.23J in order to prevent the severe distress that he had experienced when they went with mom in July, where they're calling.
Sorry, go ahead.
And he could have filed a motion for supervised visitation then and had
He
it
did.
decided by the court.
He
And
did.
had it decided by the court. And if the court decided to order that relief, okay, that's fine. Then he's gone through the system. But
He
he's
filed-
basically employing self-help here.
He filed a motion for supervised parenting time
How long
on
had,
July 29th, 2024.
and how long had he been agreeing to the children's requirements before that?
That was prior to the children refusing to go with him. That was in response to the children's distress. He filed the motion on July 29th. The children were supposed to go back to mom on August 5th. That was the first time they refused.
But we're talking about 2025 now. Judge Wallace's question was not about what happened previously. It's okay, the stipulation expires. We're back to the week on, week off. You've answered and he gave the explanation. He did what he did. And Judge Wallace's question was, well, why didn't he in 2025 file such a motion? And he didn't. The reality is he didn't. And, you know, the record played out in 2025 the way it did. I just wanted to clarify for my purposes, not for the, can't speak for the other judges, the issue of what the parenting time order was in 2025. And I appreciate your clarification on that.
There was no additional motion filed because those prior motions from both parties regarding the parenting time were still pending and hearings were still scheduled to be heard. So there was no additional motion filed after the expiration of the reunification therapy order.
Okay. Thank you. Judge Wallace, any other questions?
No other questions, but thank you.
Judge Levinsky?
No more questions.
Your Honor, just as a
Yep,
closing
please.
point to
Yep.
this is, I would suggest that should this court be persuaded that he should have been the parent and insisted that they go with mom, then the remedies outlined in the Parenting Time Enforcement Act say that she's entitled to makeup time. Maybe he's required to pay a sanction. There is no basis for a modification of custody, and that is a stare decisis issue with no less than 3 cases. Kaiser, Adams, and Mayer all saying that we cannot base a change of custody based solely on parenting time denials. That's all we have here is parenting time denials. There's no bad action beyond him not taking aggressive enough steps to make the kids do something they didn't want to do. And so therefore the modification was inappropriate and should be vacated.
Right. Thank you.
I'll reserve the rest of my time for a rebuttal if there is anything regarding following Ms. Gordon.
Thank you, Ms. Schmidt. All right, Ms. Gordon, you didn't preserve oral argument, but we, I think, indicated an order which allowed you to appear if we have questions. Let me see if any judges have questions. Judge Wallace indicating no. Judge Levinsky, no. I don't have any questions either. Thank you for being with us, Ms. Gordon. We appreciate your advocacy on behalf of yourself through your written submissions, and we'll review the record. Nothing to rebut, but Ms. Schmidt, anything closing?
Nothing in closing, Your Honor. Thank you for your time.
All right. Thank you. This matter is, the oral argument is completed. Matter 376-389, which is matter 10 on the court's June 2006 panel 6 docket is submitted, and we'll issue an opinion at such time as we're able to. All right. Thank you. Next case is the matter of Campbell versus Campbell. Plaintiff appellee is represented by Attorney Day and Attorney Bryan. Defendant is represented by Ms. Speaker.
Good afternoon, Your Honors.
And I see Ms. Speaker.
Lisa Speaker on behalf of the appellant father, Alex Campbell, who is also with me in the courtroom today.
Thank you.
So this case simply is about a father who wants to be able to spend more time with his children. He may not have been the perfect husband, but the Custody Act is not about his relationship with his ex-wife. It's about his relationship with his children. So on appeal, we raised two issues, one regarding the established custodial environment and the other about the best interest factors. I did want to clarify something that was raised in Brother Counsel's brief about the timing of the ECE issue. And a very small part of our established custodial environment issue had to do with the timing of the evidence. And I do concede that Mr. Day was correct that that issue was something that was requested by trial counsel. And I apologize for the oversight that we didn't catch that when we were writing our brief. But that doesn't change the rest of the arguments that we had made under the established custodial environment that I just want to briefly, I'm not going to go through everything, don't worry. But to briefly touch on the established custodial environment issue and, really want to turn your attention to the statutory language, which is about, we know about it's who the child looks to for guidance, discipline, necessities, life. That's the phrase that everybody uses all the time, but the statute has a lot more in it than that. It talks about how the environment's established with the child's environment's established over an appreciable amount of time and who the child looks to in that custodian in that environment for those things. And so to me, that environment refers to when they're with one parent versus when they're with another. So a child could be with one parent and still be looking to the other parent who's not present. And so the evidence in this case shows that when the children are with their father, at least as the time of the trial in July of 2025, they did look to their father for guidance, discipline, necessities of life, and parental comfort. And so for the trial court to hold that there was only an established custodial environment with the mother, we think was clearly erroneous fact finding.
Does that matter? Because if you prevail and the established custodial environment should have been with both parents, that wouldn't have any impact on the evidentiary burden regarding custody at trial, am I right?
Right. So, and we did raise a best interest issue, but I think I'm really glad you asked the question because it's really not so much for this trial. Yeah, it makes a difference as to whether there had to be a preponderance of the evidence or clear and convincing evidence.
Still clear and convincing evidence to change.
Only if it changes the established custodial environment.
Right.
So for this, let's just talk about what we have in front of us right now. With the established custodial environment being with mother only, that means the next time that the children are older and there's a seeking of modification of parenting time, it's going to be harder for the father, my client, to have more time with his children, like when they're in school, because he's going to have to meet a clear and convincing burden. Whereas if the trial court had what we believe correctly, if she had correctly held that there was an established custodial environment with both parents, then having minor changes or even major changes wouldn't necessarily change the established custodial environment. It would retain it with both parents. It's with both parents now, it's with both parents in the future. But now he's facing a higher clear and convincing burden. Like if he wanted to file a motion to modify parenting time, to increase his parenting time once the child starts school, it's going to be harder for him to meet that burden because he's going to be faced with the clear and convincing burden based on the judge's ruling in July 2025 that the established custodial environment was with mother only. And I did want to point out that in November, when the judge held the beginning of the trial in March of 2025, she said that based on the evidence in front of her then, as of November 2024, when the parties were just separating, her statement was that there were elements of a joint established custodial environment beginning to develop in the months immediately preceding separation. So even back in March, she was looking at the facts from the past and saying, even in November, I'm beginning to see it was heading in the direction of of a joint established custodial environment. But come July, she says that kind of throws that out the window, even though now at that point in July, she has evidence from November, December, all the way through to July, 8 more months of evidence of the parents then living in separate households, of the children spending time with their father in his household and looking to him for guidance, discipline, necessity of life, and comfort while they're with him in his household. She throws that all out the window and says, you know what? It's only with mother. In spite of the evidence that the situation had changed dramatically once the parties separated.
Maybe I'm remembering this wrong, but didn't your client object to evidence from after November 2024?
Yeah, at the March 2025 hearing, Your Honor. And that was what I conceded earlier, that me bringing that up earlier with regard to the March hearing. I conceded that, but at the July as my brother counsel pointed out, at the July 2025 hearing, not only did evidence from November 2024 come in, evidence from November to March came in, as well as evidence from March to July of 2025. Okay. So, and as we put in our brief, I won't belabor it, but you can have an established custodial environment in 2 different homes. The children could have less parenting time with one parent, as we cited in a couple different cases, such as the Kubler case, where the one parent may not have had as much parenting time, but that does not mean that the children are not looking to that parent in that environment for those things of discipline, guidance, necessity of life, and parental comfort. And we also raised an argument about my client being the working parent because he was primarily the working parent during the marriage and then afterwards as well. Moving to the best interest analysis, and I just wanted to touch on a couple of points really about the statutory language. For example, and I'm not going to go through everything in my brief, but I did want to highlight, for example, under factor C of the best interest analysis, it talks about the capacity and disposition of a parent to provide food, clothing, medical care, other needs of the child. And the judge said that factor favored the mother rather than the father. And a lot of what it boiled down to in the judge's mind was that the trial court said that he was not participating in the medical care. And so she said, because he's not participating in the medical care, not attending as many appointments, not asking as many questions when he was at appointments, therefore that he doesn't have the capacity and disposition to provide medical care. Well, when in fact, he is the parent who was providing medical insurance, for example. And so there's a big difference in the statutory language about providing medical care, and what the judge said, which is not in the statute, is participating in medical care. And I think it's a pretty significant difference about what was actually happening. He's providing medical care, by way of example, by being the parent who's providing the medical insurance so the children can see the doctor.
Right, but I mean, my memory is that just using the prenatal appointments for the expected child 2 out of 20, your client went to either 1 or 2 at the most, and didn't attend, the baby checkups. I mean, how is that not appropriate for the trial court to take? And I understand he's employed in an exceptional firm, and he provides the healthcare insurance through his employer, or if he's a partner through his firm. And that's substantial and significant. But how is it an error of fact or law for the trial judge to put that into the calculus as far as how many times you go?
So you don't need 2 parents to go to a prenatal appointment. You need the mother who's pregnant.
Well, that's
right?
an important one. Yeah. Being the father of
And
3 and grandfather of 2 and 3
Having been
quarters.
through pregnancies myself, like my husband wasn't there very often. That doesn't matter. But the point is, you just need the one person there. And as far as the well baby visits, the mother had serious, I'm going to call it scorched earth. She did not want to be around father. So I guess he could have insisted, he could have taken off time to go from work to go to the appointment with her. But I think To say like, because he didn't attend an appointment that she was able to attend with the child, to say that he did not have the capacity or disposition to provide medical care, I think is erroneous.
Was there only one? We know there's the one incident where after the second child is born, he's not put on the list of visitors, and is then not allowed to spend much time with the child. Was there only one of those incidents, or were there multiple incidents where that happened?
Your Honor, I
This is
don't.
right after birth, right?
Right after the
Yeah.
birth, he was not even put on the visitor list, and I don't know that there were other instances, and I don't know that the record, if there was, I don't know that the record reflects that. I apologize that I don't know that offhand, but I don't think so. So I'll just have to stand by, the fact that he wasn't even on the visitor list and was only able to hold his daughter, his brand new baby daughter, for just literally 2 minutes before he was kicked out and told not to come back. When she was born in January of 2025. I wanted to briefly touch on the moral fitness factor as well. And as I said earlier, he might not have been the perfect husband, but moral fitness has to do with you as a parent, not as a spouse. And the judge put a lot of emphasis, as did his ex-wife, on the fact that he had an extramarital affair, which, among other things, led to the end of the marriage. But that really is not about how he is as a parent, how he is with his children. There was also an allegation, and this really bothers me because there was an allegation about, and the trial court relying on it, about, I'm going to use the quote, illegal drug use. And that was part of the moral fitness, that he admitted to the FOC worker that on occasion he would take an Adderall pill that was not prescribed to him. So yes, there was use of an unprescribed drug. To call it illegal drug use is like a little bit of hyperbole. He also said to that FOC worker who testified that he only did that when he had really long work days. So not only I'm not condoning it, but the fact of the matter is it wasn't about him as a parent. It wasn't about him being around his children, because it was when he had really long work days when he wasn't around his children. So again, going to the moral fitness factor, it's about you as a parent. It's not you as a person. It's not you as a spouse. And I think it was a little misguided for the court to emphasize those two things in particular. And at the same time, disregarding the mother's attempts to fabricate evidence to prevent him from having a relationship with his children, I think that does speak to her as a parent. We have examples of where she typed up an affidavit for her mother-in-law to sign that was completely made up and eventually did not make it into the record. But there was testimony about all the things that she wanted their mother-in-law to say. And then, that it came to light that she had falsified this. There was a parenting time schedule that was a subject of the March 2025 hearing, where the mom was showing like, hey, dad doesn't spend even a minute with the kids. All these weeks go by. And in fact, the evidence at trial showed that he was spending time with the children. Or at that point, it was just the older daughter, because we're only talking about November and before. He had been spending time with her every single day. So that was shown that she was putting forward a schedule to make it look like he didn't want to be around his children. So just a couple of examples like that, which I think does weigh on to the moral fitness as a parent, because she's trying to prevent him from having a relationship, which then, of course, ties into factor J. Now, I somehow misread the opinion. The trial court said that factor J slightly favored father, and I read it somehow to say it slightly favored mother. I still take issue with the fact that the trial court said that factor J only slightly favored father, when the whole case was a kind of a scorched earth mentality about trying to disparage the father, trying to prevent him from having time with his children, from telling people in front of the children that they shouldn't call him father, they should call him, or dad, they should call him Alex. One example from the text messages that came into evidence was that mom preferred to have other people take care of the kids, instead of the father. Instead of saying, dad, can you help with the kids, and giving him a chance to be around the kids more, she 99 different times was a testimony based on the text messages that were in evidence. 99 times from January to July, she asked other people to help with the kids, and not once did she ask the father of the children to help out with the kids. So it just shows this pattern of her trying to exclude him from the children's life. And I understand she was upset, emotionally distraught, going through a divorce while pregnant. But this is really about the parents' relationships with the children, not with the relationship with each other. So with that, if I could, I would like to reserve 3 minutes for rebuttal.
I think you probably have. Yes,
Thank you, Your Honors.
thank you.
Thank you.
Good afternoon, Devin Day on behalf of the appellee. I have a few points I want to make. I want to address sort of things in a little bit in order in which they came in. The issue about the established custodial environment, Judge, I think that the answer, hey, this will affect things in the future, that's not my reading of the statute. My reading of the statute is that anytime there's a request to change things now or in the future, the judge has to revisit this issue. So just because an established custodial environment existed solely with mom so far doesn't mean that he can't cultivate one going forward. And I think that some of the judge's comments where she said, I see some of these things starting to form, I think those were less fact finding and more encouragement. Keep it up. Keep building your relationship. At some point, it may come to exist. And that's
what happened in the Keebler case, right?
I think that's right. And I think that's good judging. And I think the judge was mindful of that. So I don't know whether there's a strong concern on the court about the ECE issue, because at the end of the day, he got about as much parenting time as I think he can handle with his job requirements and so forth. So some of this to some extent is labeling, as I
And I'm going to ask Sister Counsel this question too. What's the status right now? I mean, of how much does mom get? How much does dad get? And I'm not asking you to comment on her. Oh, are they getting along? I'm not asking that, but just what's the amount of time that's indicated?
So at this point, they're operating under the judgment of divorce, which was based largely on the judge's opinion. And then with regard to the younger child, based on the agreement of the parties. So what the older child has currently under the judgment is,
Let's the initials for the
EJ. The older child has alternate weekends from Friday at 4 until Sunday at 6. Every Wednesday overnight from 4 in the afternoon till 9 a.m. taking the child to daycare, and then alternate Monday evenings for 2.5 hours. The younger child has had a progressive schedule under the judgment of divorce that changed over time, increasing parenting time over time. And at this point, they're in the final phase 3, which started in November of last year, has alternate weekends also, every Wednesday overnight also, and then alternate Monday evenings from 4 to 6:30 p.m. So they're almost matched at this point. And I would submit this is a reasonably standard, if not generous, parenting time plan for a non-primary custodial parent and working parent. So, not to put too large a point on it, but at some point we're arguing over winners and losers more than we are over outcomes. And so from my perspective, I suspect that.
Are either parents remarried?
No, not at this point.
Do either parents have live-in partners, companions of the, I don't care what gender, I would have.
I don't think there's any issues here
Old
with
Jim
that.
would have said of the opposite sex, but I'm not saying that, do they have domestic partners?
There is no record on that. My understanding informally is that neither has anyone they're living with currently of the, significant others.
We can admit, though, that having an established custodial environment is still pretty important under Michigan law, is it not? It seemed like you're kind of brushing that off like it's not a big deal.
No, well, what I'm trying to do is just focus my argument on things that are important to the court. But no,
That- I
it's
mean, that
certainly
should be important to us, shouldn't it?
it should be. It is. It is a hallmark of sorts. And I think it is an important thing that the court found it to exist with mother, and it's significant that the court found it exists only with her. And I do take to heart some of the arguments that he makes. I think, frankly, as a lawyer, the most interesting issue in the case is this Bafacil issue, which I think is sort of a unique case. I actually like the case, but I think it needs some consideration on how it's applied. I think there's some danger in the case for us as a court and as a system. The way I view that case and the way I understand the argument is that Bafacil comes in and says, look, we understand some parents work. In that case, it was an extraordinary work schedule, limited time for the parent to spend with the children. And then they looked at the case and said that the working parent made tremendous use and the best use possible of the limited time that she had available. Made lunches every single day for the family, was there when the child got up, organized to the extent they could their work schedule around spending time with the children. Okay. So that case I view as one that says, hey, even if you are relegated to a limited period of time, if you do everything in your power to try to focus on your children, you can still become a parent with an established custodial environment. Here's the concern I have about that case, and this case illustrates it. The arguments here illustrate it. The focus of that case is on the challenges the parent has and what the parent is doing, and not necessarily on the child and the relationship that's cultivated. Okay. If you rely on that case to say, hey, I'm a working parent, therefore I don't have to show as much. I don't have to have the same quality of relationship because I'm working. And that's what Bafacil addressed. That's the argument I see being made by the appellant here that says, look, I'm working all the time, and therefore I don't have to have the same quality relationship as the non-working parent may have cultivated. I think that's a bridge too far. I don't think we want to go there because it makes it a best interest of the parent perspective rather than best interest of the child perspective. The way I read Bafacil, and I think this court could emphasize, that parent in that case moved everything she could move to have the best relationship she could with the parents or with the children. This case, as I see the record evidence, is not quite that. This case is a working parent who, by choice, has decided, working in a big law firm with great working requirements, trying to get ahead in that law firm and choosing that to prioritize over spending time. You see the difference. One is, I have to do this.
For which that person's children will be enormous beneficiaries of if they become a tier one equity partner in one of the most, storied firms. And I don't care if it's the one that this person is at or if it's, Redford. I mean, so you don't get to be the managing partner of the mergers and acquisitions group or the transaction or the defensive litigation group or the bet the Fortune 50 company group by, doing the bare minimum when you're up for non-equity, when you're up for equity, and then you wake up 5 years later and say, oh, I want to be the bet the corporation guy. Guess what? Train left the station about 12 years ago. So, and I'm not suggesting that you do this to the exclusion, but I read that in your brief on that. The children, yes, it's a sacrifice. It is no question a sacrifice in a big law firm or if you have two jobs or whatever. But at 10 years down the road, 20 years down the road, when your children are deciding whether they're going to go to one of the Seven Sisters colleges or an Ivy League school or Stanford and not have to take out ginormous amounts of student loan debt is directly because of the time that was put in when they were 2, 3, and 4. I mean, I can't tell you how many anniversaries, birthdays, and everything else I missed because of the US Navy. But because I did that, it was a privilege to serve. But now my family has the benefit of the thanks of the nation through the form of a Navy pension.
Sure.
I mean, life's about a lot of pieces. And to say that, and anyway.
Yeah. Well, Judge, I'm a practicing lawyer and
Yeah,
partner
no
myself.
kidding. Yeah.
I do understand these things, I think, personal level. But what I view and the thing I want to focus on with the Boffisil case is it's about prioritizing, okay, and then understanding what the analysis we're trying to figure out here. And the thing we're trying to figure out is, do the children have an established environment with the parent in the same way? You're absolutely right. It requires sacrifice to have an ambitious career. Okay. And there are trade-offs. Those trade-offs are probably reflected very well in the best interest factors. Okay. Not necessarily in the established custodial environment. The question is, where do the children, who do they look to? And what is the relationship with that parent? In this particular case, the parent who altered her schedule to be there to the extent possible, and we have two working parents in this case, a little different than Boffisil, ordered her schedule in such a way as to maximize that relationship and the cultivation of it. The appellant ordered his schedule in a way to minimize contact with the family, probably because of all the other things that were going on in the case. Okay. Delved into work, worked way beyond the requirements of the firm. And as a result, sacrificed the cultivation of the established custodial environment. That's the reality of it. Will the children someday be better off? Perhaps. Do we all go to work? Do I go to work in the morning thinking I am providing in many ways? Yes. That's an analysis under best interests. That's has its own rewards. But the question here that the court was grappling with was, who has the established custodial environment? And the reality is that she did.
Okay.
So under the best interest factors, I can move through them quickly. My time's probably.
You already covered all of them in the brief, I think, correct?
Okay.
Anybody need to hear
Then
them
I'm
again?
satisfied.
Okay, I do not, but.
Thank you.
Okay, all right, thank you. Any final comments, Ms. Speaker? And I'll just give you both a heads up. I'm going to be making, I have a number of comments that are going to happen before this case is submitted. It's not a criticism, but I'm going to talk for a little bit. Go ahead.
Thank you, Your Honor. I have 3 points to make on rebuttal, which includes answering one of your questions, Judge Redford. So I'm going to get to it. And if I don't, you'll hopefully will remind me. First, I wanted to point out regarding the first argument with the established custodial environment and what I was explaining about how it's going to make it harder in the future. But the reality is, in this case, what we're presently faced with is that the judge said in March, based on the situation in November and prior, there wasn't an ECE yet. Maybe there was, like, she could see one on the horizon, but it hadn't happened yet as of November 2024. But then in July of 2025, she said, you know what, you haven't persuaded me that it's changed enough, that you've moved the needle enough. And I'm kind of paraphrasing exactly what she said. So she put that burden on him within the context of this very case, instead of looking at after November 2024, once the parties separated, that's when Dad really started to step up and be more of a parent to these children and have the opportunity for the children to look to him, which they did, which the evidence demonstrated that they did. And that ties into the Boffisil argument, because I want to point out that I think we can admit that during the marriage, the father wasn't as involved. And it wasn't really until they were separated that he was like, wait a minute, even when they were living in the same house for those couple of months, when they're living in the same house, and he realizes he needs to change some things to have a relationship with his children. So that evidence started coming in September, October, November 2024. He really stepped up to become a father and to have the children be able to look to him. But there were roadblocks.
You say it started to happen in September, October, November of 2024, and you concede that with respect to established custodial environment, they had to look at November of 2024 and before only.
No, I didn't concede that, Your Honor.
Your issue on appeal was they failed to consider the information from post-November of 2024 when deciding ECE. What did you concede there?
So I conceded that the concession was that at the March trial counsel said, don't look at anything after November 2024 for purposes of that March trial, which was an ECE trial. And I missed that statement by the trial attorney.
That's what I just said, that it's not. So in other words, they were supposed to only consider through November of 2024 for ECE.
For purposes of that March trial,
Yeah.
but by the time we got to the final trial in July,
Which was on best interests.
but it was everything. So that there was evidence that came in at the July 2025 trial about the established custodial environment. And the judge looked at it again. She looked at it in March based on the old evidence. And then she looked at it again in July and said, you know what, you haven't moved the needle. But that really gets to the heart of the problem, is that even though brother counsel says, well, you have a chance to put on evidence and make a case, it's always you look at the ECE afresh. But even in the context of this very trial, when he put on more evidence to show how the children looked to him for all the things in the environment that they were at when they were with him, the judge was like, it's putting a higher burden on the father to get any kind of modification, as we see from the very context of the trial in this case, which can then be extrapolated that it's going to be, again, I like Judge McNabb a lot. She's a very good judge. But he's going to be in front of Judge McNabb again. If he goes in front of her in 2 years, she's going to be putting a higher burden on him to establish that something's changed. And that was kind of the point of the established custodial environment argument. To answer Judge Redford's question, the status now, the children are on the same schedule. So now they've reached a point that they're on the same schedule. I think they weren't quite on the same schedule at the July 2025 trial. So that schedule, so now the younger daughter has caught up with her older sister. And as brother counsel said, there's alternating weekends, every Wednesday overnight, and then plus an alternating Monday evening. So my client has 4 out of 14 days for that time period. And to my knowledge, neither party has a living companion. They're living independently, raising the children on their own. The main thing, going back to the working parent situation, so our case is not exactly aligned with Befeisel, because in Befeisel, the mother in that case was very involved during the marriage, which was part of what the Court of Appeals was looking at in that decision. Our case is a little bit different because my client became way more involved by the time that the parents are deciding to separate, even before they lived in separate homes. And so it's just a little bit different in that regard, but it's still punishing a working parent who wants to be involved and who has rearranged his schedule. So he reduced his work hours. When he has the children, he's leaving at 4 o'clock in the afternoon, going to work at 9 a.m. to have more time with the children. And I think a really important point that came out at trial was that when he has the kids, it is him taking care of the kids. Other people aren't involved. They're not third parties helping him out. Whereas mom is apparently 99 times asking for other people to help her out. And I'm not saying that is a bad thing for her, but we can't to say that he is the one that is actively participating when it is his parenting time, even though he only has 4 out of 14 days. He is trying to be that person for them to look to. And the evidence demonstrated that when they're with him, they do look to him for all those things that establish an established custodial environment. Did I answer the questions that you had brought up during posing arguments? Okay. Thank you very much, Your Honor.
You're welcome. All right. Matter will be submitted, but before we adjourn on this case, I want to make a couple of comments. Every case is serious. Some cases, and this case is serious. There is no judicial decision in 41 years that I've been a lawyer or a judge that I think surpasses the effectiveness of what 2 intelligent, hardworking, well-intentioned, well-prepared litigants could reach in a resolution on their own. I was a circuit judge for 12 years. I was never on the domestic docket. I represented sailors and Marines in not in the courtroom, but when they were going through divorces for 28 years in various ways or the other. But I don't have anywhere near the experience that the lawyers here in this case do, or probably the two colleagues here. But we've got two litigants, both have doctorates. Two litigants have great educations, great degrees. Most importantly, two litigants who unequivocally and unqualified love their children. What I would urge these litigants to do is to tell their lawyers, ask the Court of Appeals to stay this for 1 month and give us a chance to try to facilitate, to work through. Let us agree, because we want to look at what does the 20 years from now look like? How do I look as a dad 20 years from now when my daughter's graduating from college and I say, you know, your mom and I had a hard time. We couldn't get together, but we gave up our personal concerns for you. And if I'm the mom, I want to be able to say that same thing. And you have that chance. You are not going to have that chance indefinitely. Both of these people obviously care for their children. This weekend, I will have been married 40 years. It's beyond, I can't even imagine that I've been married that long. And there were really difficult times that we got help. And I'm not saying this couple's ever going to get back together, but they have every single tool in the toolbox that is necessary to co-parent and to lead these children to remarkably successful and supportive and mutually respectful upbringing. And I would just, 990 litigants who have cases like this do not have these tools. They don't have the resources that these two litigants do. But we're arguing over one thing. And it's important, and we're going to issue an opinion of whatever the panel, at least two of us agree on, and we'll do that. We'll do our duty. But I can't believe, with the very fine lawyering at the speaker firm and the very fine lawyering at Mr. May's firm, that you can't get this worked out in a better way that is sustainable, that gives a blueprint for this family and, most importantly, for these children. That's my preaching for the day. I hope it's my preaching for the case call, and I apologize if anybody's offended by it, but I just feel, as I look at literally 40 years on coming up, seeing our granddaughters soon, it doesn't have to be this way. And two really smart people can make it go forward for these two wonderful children that they have. That's all I've got. Anybody have any objections to my comments, Ms. Speaker? Mr. May? Day, sorry. All right, thank you. All right, this matter is submitted. Court calls next two final cases, case 10 and case 12. The first is Gordon versus, no, I'm sorry, not 10 and 12. 9 and 12, Sheffield versus Chippewa, 374-645, and Armour versus Kalamazoo County, 375-423. We'll address them one at a time. We'll incorporate by reference things that you tell us we should, which I suspect will be almost everything. But anything else before we go to the next one? No. All right. Please proceed.
Please, the court, Donald Visser, on behalf of the appellants in this matter and the claimants under the constitutional claims that were made in the case. May, I'd like to reserve 5 minutes for rebuttal. I don't know if you'd prefer to have rebuttal at the end of the totality.
No, I think we probably need to do one case at a time. What do you think, Mr. Wallace?
Yeah.
Judge? or Mr. Judge Wallace. Yeah, so we'll go one at a time. We've read everything. You don't need to say in the beginning of time, God created property, so just, we're ready.
All right, thank you, Your Honor. I think the core problem that I have with a number of these cases, this is kind of a second or third generation now of claims under the General Property Tax Act for tax foreclosures. And this has to do with kind of the interrelationship between the constitutional claims and the 78 claims made under MCL 211.78T. And the basic concept that I have a problem with, the starting concept for these cases is how can somebody who has a vested claim be divested of that claim?
Well, let's stop for a second. So as far as the other case goes, we see from the Register of Action that apparently there was some type of settlement. So is your client, well, what was the result of that case?
The Armour case?
I'm talking about Sheffield.
In Sheffield, what was the result?
Yeah.
We're still pending in front of this court for at least one of the claims.
No, I'm talking about in the other case that I think it's the original foreclosure case, the Register of Action says that there was some type of settlement reached. What was that?
There's settlement reached for some parties, but not.
Didn't pertain to Sheffield at all.
Not to Sheffield. And what happened in those cases, and I'll make some clarification because it was brought up in Sheffield, is that the claimants and the FGUs, the foreclosing governmental units, decided to settle claims, which would be the 78T claims as well as the constitutional claims. So those claims were settled for a premium above the 78T amount. And as a result, the 78T claims were either dismissed or withdrawn. Usually they would, I don't know, because we've done this in so many cases across the state. They were withdrawn, and then the corresponding constitutional claim that was pending in either state or federal court were dismissed. So that's why you have some cases, some appellants in some of these cases have been dismissed because they resolve both 78T claim as part of a global settlement of their claims.
So go ahead.
So Chippewa County currently still possesses the excess proceeds from Ms. Sheffield's property, correct?
I don't think that's correct, is it?
I don't think that is correct.
So if it's not correct, if the money is no longer in the property of the forfeiting government unit, Mr. Visser, my good friend of so many years, why are we here on this case?
Because now you've gone over into the Sheffield case primarily because that's not the case with the Armour.
But we're arguing number 9 right now.
Yeah, we started on the Sheffield.
I got myself confused. I'm sorry.
We apologize if we created a confusion.
I probably did.
So we're talking about number 9 right now, Ms. Sheffield. So her excess proceeds, that matter has been resolved below, correct?
That matter has been resolved below. That's correct.
So all that's left in that matter is whether is it still true that you're arguing whether she should get interest or should be able to pursue the constitutional claims?
She's entitled to complete relief for state claims. She's entitled for complete relief, which is the 5% that was not paid plus the interest on the claim.
Hey, can you hold on a second? Scott, there's some bottles of water in the fridge. I really need one. Do you want one?
No, I'm good. Thanks.
Like me to wait for the.
Go ahead, please.
And I guess I would just say, if we're going to address the plaintiffs, I mean, there are kind of 4 plaintiffs in this case, right?
Right. Are McDonald, Halstead, and Strauss are out of the case?
Yeah, they're all out.
They are out.
Okay. So we just have Sheffield left.
That is, from my standpoint, that's correct.
Okay.
And so then the obvious question is why is that 5% plus the interest issue? Why isn't that more properly litigated in the in the foreclosure case?
Because it's a taking. There's no question that it was a taking. These are all pre-Raffaelli. These are all pre-78T claims. So we have an established taking as of that date. There's no question about it. Raffaelli says it's a taking. Under Tyler, under the federal law, says it's a taking. So you have a taking that's established at that time. At that time, you're entitled to full relief under both federal and state law. You're entitled to 100% of what was taken, and you're entitled to interest on that. Furthermore, under federal claims, which were asserted in this case, you're also entitled to attorney fees. Now, there's some suggestion that in state law, under the Miller versus Michigan Department of Natural Resources, that attorney fees might be available as a result of failure to follow the Uniform Condemnation Procedures Act, but certainly that there can't be any question that under federal law, 1983, that's available. Those are vested claims. And there's no, I can't imagine any way that the Michigan legislature can come back after the fact and say, in 2020, by the way, if the Michigan Supreme Court ever rules, then we're going to impose a difference. We're going to impose upon you the requirement to follow the 78T. So, which of course happened on July 29 of 2024. So now suddenly we have this procedure by which you could recover 95%, but you can't recover everything. So you still have a constitutional claim. Now, the judges of the Eastern District, federal judges, suggested, well, maybe the constitutional claims, maybe this is just additional compensation. In addition, the state gave you remaining proceeds, but you're still entitled to your constitutional claims. That it hasn't been replaced. It can't be replaced. I'm not going that far. I think there's a set off for the 95%. But that's what you have is you have the claim. Now, underlying my state concern. Now, I think federal law is pretty clean because Williams versus Reed says when Congress authorizes action, you can't, no state law can then thereafter preempt it. Federal law preempts state law in that regard. And that was a case where they tried to impose some administrative procedures before you could pursue your claim. And the court said, no, you can't. The state law can't do that to a federal action. I'm more focused today on what the state claim is because I think that's where there's a great deal of confusion. The state claim, of course, is constitutional, is based in the Article 10, Section 2, the State Takings Clause, which disables government from taking anything unless they first make payment. Very dislike the Fifth Amendment, which the Fifth Amendment doesn't impact.
So if that's, I want to be flippant, but how can that possibly be?
Because the Constitution says so.
The Constitution says you got to pay for it before you get it. How about the claim called inverse condemnation? I spent the last 2.5 years presiding over a case involving it. And there are mechanisms by which a property owner, fee holder, can get their property value from the state under the state constitution.
There's a thing called inverse condemnation, which if the government, for instance, goes through and by zoning or otherwise
Yes,
it doesn't take ownership. That's the important thing there. It doesn't take ownership. It doesn't try to take possession of the property. It just precludes you from making meaningful use of your property. That's called a taking. Now, when you try to take under what the government's trying to do here is to take the surplus proceeds, ownership. And our Constitution, Bowserman and even Raffaelli, and now most recently Schaefer, which cites to Bowserman, says you can't do that. Now, Raffaelli says that our Constitution provides more protection than the Fifth Amendment does. We have very few cases that actually quantify what that additional protection is. Raffaelli touches it on just briefly. It says it impacts the ability of government to take. And that's a huge difference between federal and state. Government does not have the ability to take, that is, take ownership, take possession, unless it complies with its takings clause. And that inverts the whole relationship. The federal and most states have a compensation requirement that if government takes, it must pay compensation. It does not address the ability of government to take. Our Constitution, 1993, when we were addressing a lot of annexation issues and everything, our Constitution says we're going to really restrict government, and we say it shall not take unless it first makes compensation. And I realize it's very inconvenient relative to how the process works in the federal scheme, because you take and you have to pay. But that's not what happens in Michigan. And we need to have a case that addresses whether that, I would say Bowserman says we have to address it. What does it mean when our state constitution says the state may not take without first making payment? And that's it. Raffaelli says that impacts the ability. That's the term that Raffaelli uses, the ability of government to take. So now, are they taking? Raffaelli also says they took. So it's an unconstitutional possession. At that particular point, you can pass whatever statute you want. You can't undo the constitutional violation and say, well, we're going to give you 95%. You still have to comply. And we're not talking, the methodology when the government doesn't follow it is yes, an inverse condemnation. But I would suggest to the court that most of the time the inverse condemnation statute is used is not when government attempts to end run the taking statute or the Uniform Condemnation Procedures Act, but instead when it effectively takes by zoning or other regulations taking away the property. When you really look at a case where the government's trying to take ownership or possession of property, different than zoning, then you have to really look at how does Article 10, Section 2 of the Constitution, how does that impact what the government is trying to do? Miller versus Michigan Department of Natural Resources makes it very clear that the Uniform Condemnation Procedures Act is the exclusive methodology by which somebody can take property. In effect, what the legislature is trying to do at this point is to say, well, there's another way. We can take some of your property, 5% of your property, or we could take the whole before 78T was applicable. We can take all of your property under a different methodology. And of course, that's violative of the Constitution.
Okay, your argument is on Section 2, Article 10, correct?
That's correct.
Is the first paragraph that you're arguing?
First sentence, private property shall not be taken for public use without just compensation, therefore being first made or secured in a manner prescribed by law. Okay. And that was violated back in 2017 for Sheffield.
In a manner prescribed by law.
Correct.
You have 78T.
It didn't exist in 2017.
Right, but 78T has in the cases that have applied it, have said, if you were affected before the effective date of the statute, you got X period of time to deal with it. This is the sole mechanism by which you can go through it.
I think that's an overextension of what the cases have said, Your Honor.
Which case doesn't say that?
I can't define a case that doesn't say it because I don't think any case says that. We have the post-Raffaelli or the
yeah, I mean, I literally wrote 3 of the opinions. I mean, I have a working familiarity with this area of law, I think.
You've been involved in a couple of mine. I understand.
And I think I was upheld by the Supreme Court most recently. The opinion that I wrote and the panel joined in was adopted by the Supreme Court.
You're talking about Schaefer?
Yes.
Schaefer is a pre?
I understand. My point is, counsel, I haven't been reversed every single time I've written. In fact, I'm not sure I have been. At any rate, I just have trouble understanding if that which you suggest is the rule based on both the state and the federal constitution, I don't understand some of the federal constitutional cases that have said, if so long as the state has a system, so long as there's due process, we're going to allow it. I mean, you're making these arguments that are so, is there any system that would work that would satisfy your requirements?
Well, I'm starting to see, I think, a bit of your thinking, so I want to try to address that, Judge Redford. Schaefer was a pre-Raffaelli or pre-78T case, had only constitutional claims. Your panel affirmed that it was retroactive, and the Michigan Supreme Court affirmed that in a 7-0 decision that it was retroactively to be applied. There were no 78T claims involved in Schaefer. So we didn't address how those two interplay. The rest of the cases that have been in front of the court, including, let's say, in Ray Muskegon and so forth, are all post-2020 cases. And while I don't agree with some of the logic, especially in Ray Muskegon, because it left a couple of important things out, what it says is when there has been appropriate notice prior to the foreclosure process, when there had been appropriate notice, then cases like Nelson gets some application and so forth. You don't have that in any of the cases prior to 78T because there was no notice.
After 78T, Mr. Visser, didn't litigants have a period of time, either statutorily or by case law, that if you were affected before this, here's what you have to do. And you have to give notice and there was a certain amount of time given. Am I just not remembering that correctly at all?
I think you're simplifying it too much and trying to squeeze everything into the same vessel. That's really.
Stop, please. Was there a either legislative or judicial decision that addressed people like Ms. Sheffield that said you were injured by this governmental operation, my words, not theirs, before 78T? You need to use the 78T process and you have X number of months, years to do it. Did that happen or am I not remembering this correctly?
Under 78T 1B, it became effective to pre-Raffaelli cases once Schaefer was issued.
Why isn't that enough due process?
Because it's already occurred. The violation occurred in 2017. You can't unring that bell. If there's been.
The Constitution says as statutorily in a manner prescribed by law.
It wasn't prescribed by law. The taking occurred. You can't fix it afterwards and say, oh, I'm going to give it to you afterwards. So therefore.
So your position is you can never fix it, correct?
You can, once you have a unconstitutional taking, you have a factually unconstitutional taking. You can do a bunch of things that what you want to try to remedy it, but you can't undo that taking. So you have a vested right, and a number of cases have said you can't take, the legislature cannot take a vested right away. Now, I think it's important for this court to look at some of the dichotomy between the pre and post by looking at what 78L says. 78L was changed significantly on December 22 of 2020. Before that, it said the only remedy somebody has for lack of notice is you may go to the Court of Claims and file a claim based upon fair market value. The modifications of 78L on December 22 of 2020 was now you must follow the procedure under 78T, and for any violation, including violations of state or federal constitution. I don't think you can do that. I don't think the state can impact any claims under a federal, but that's what it says now. In Schaefer, the court addressed that and said 78L modifications are prospective only and not retroactive. So this whole thing of squeezing all of the constitutional claims into a 78T exists for post-Raffaele claims, but not for pre-Raffaele claims. The Michigan Supreme Court specifically said that new definition of what you have to squeeze through the 78T process is not applicable. So I don't think the statute in this instance applies to the constitutional claims because we didn't have that statute, and the Supreme Court says it doesn't apply.
Can I ask this? I guess I think I understand your conceptually here. I'm not sure as to the remedy, but you're basically saying federal and state constitutional claims arose in 2017. They continued to exist until 2020. In 2020, there was a statutory claim. You're not denying that your client needed to go through that statutory remedy, right? You're just saying that that statutory remedy doesn't eliminate those constitutional claims you had from 2017 to 2020, right?
I would basically agree with your premise, except if you said as of 2020, I think it would be as of 2024 when it became applicable to.
Fair. Thank you. You're right. It only became a qualified order in 2024 under the statute. That's fair.
And I wouldn't necessarily yield the fact that we had to go through it because I think that has some, but we did go through it because we weren't willing to take that risk.
The gist here is you think a constitutional claim existed from 2017 until some period of time. And you must also be saying that whatever statutory remedy that you concede your client did go through here is just not enough because you still have these other claims out here. But what if the statute had said that you now concede you have to go through, that you get twice the surplus funds, right? Would you still have these constitutional claims to get more damages?
I haven't really thought of that.
Because what I'm really getting at is
smoke coming up.
What's the harm here, right? Like you got the money back, and I understand it's 95%, 100%, you call about attorneys. So I understand you're clinging to this principle that this violation occurred and you cannot by statute later on extinguish that constitutional violation. Say I even agree with you. Is this all a fight over 5% in attorney's fees and interest?
I think at this point it is. It definitely is.
And you're basically saying that the constitutional claims is your mechanism to get that.
I'm saying the Constitution.
Because the statutory is not enough.
Entitles my client to full compensation, not reduced compensation. And what that really means, and that's why the attorney fees are.
It doesn't say full. It says just compensation. The Constitution says just compensation. It doesn't say full compensation, and it says in a manner prescribed by law.
Just compensation has been determined, at least in the federal arena, to put the party in at least as good of a position as they would have been in.
Does it matter that
doesn't do
the
that.
people whose properties were taken chose or by mistake failed to pay their taxes for years at a time and were given written notices that they owed the government a whole bunch of money? Is that of any moment to the analysis of what is just?
It is not in my interpretation of it, because as Tyler said, as soon as the property is sold and the tax is paid, there's not a continuing obligation or debt that the party owes. They are now entitled to protection under the Constitution.
But Mr. Visser, the process by which the forfeiting governmental unit has to go through to obtain the sale of the delinquent taxpayers' property is not something that happens for free. You have to have publication. You have to have notices. You hire lawyers. You have 6 seconds until you're done.
Wow.
Okay. You're done. All right. You have 5 minutes reserved. Thank you.
Thank you.
Sorry. I mean, I just.
I'll try to answer that in rebuttal.
Next time, yeah. So if you asked for 5 minutes, you've been speaking for 25. So, all right.
Good afternoon to the panel. Douglas Curlow on behalf of the county and the treasurer. Panel will indulge me, I think, for my own sake and for the panel as well. I'd like to try to see if we can help conceptualize this. And I think Your Honor was on the right track. You were actually gelling in my own mind things I had been thinking as well as to where we're at. The big problem that I and fellow counsel have faced in these cases is that the law has been changing under our feet as we go along. I was involved in the appellate work and some of the trial work on the original Freed versus Thomas federal case that was started in 2017 and went through the Sixth Circuit. We had won that case, gotten it dismissed, and it was on appeal when the Raffaelli case came out in 2020. And suddenly the Sixth Circuit shot it back to the district court and said, nope, there's a case here based on Raffaelli. And so the whole thing that we had won was suddenly unraveled. So I know that feeling. In this case, we have the additional problem. Well, in the other case as well, they have the additional problem that after the decisions by the circuit courts in these cases to dismiss them, then the plaintiffs brought their 78T claims, and many of them made recoveries or resolved those claims after the original circuit court dismissal of their case for not following.
But the
78T.
dismissal was without prejudice.
Correct.
So wasn't that really precisely what the result should have been?
Well, I think the dismissal was what the result should have been, but now the question becomes, can this case survive as opposed to a different one? So
Let's explore that for a second. So could these, if you heard counsel say what the remaining claims are for Ms. Sheffield?
Yes.
5% in interest. Okay.
Yes.
Could those claims have been pursued in the underlying foreclosure case, the 2016 case that basically got revived so that they could pursue the excess proceeds? Could she have pursued those claims in that case prior to settling earlier that or last month?
Well, I think they argued that in that
Weren't
case.
they pled?
What's that?
Didn't they plead those prayers for relief?
Those were argued in the 78T case. Your Honor, you owe me, I believe you owe me you can't cut me to 95%. You can't take out that sale commission of 5%, and you owe me interest. And the judge said, no, I'm giving you what the 78T allows me to give you, and it doesn't include either of those things.
And the party accepted that. How are we not done?
Well, I think we are done. But
was it a settlement?
Well, Sheffield, I don't know if Sheffield was settled. I think Sheffield was actually a judgment. I think the others were settled, which is why they're no longer part of this case. Sheffield, meanwhile, got a judgment with it. She's not satisfied because she thinks the judgment or the award was too small. I think that's how the 78T claim has worked out. And that goes into why these cases that we've got here should not have gone, had to be stopped and not brought forward. That's why Howard and why Hathon both say use 78T first. Then you would have set us up so that we could have properly addressed whether or not 78T gave you proper result.
Was there any determination by the circuit court in that case, in the Sheffield case, the one where she just got a disbursement?
Yep.
Was there any determination made by the circuit court that I don't have jurisdiction or otherwise cannot decide your argument that you keep the 5% and you get interest?
I can't speak to that. I was not involved in that case. Lucas Middleton, I believe, was the attorney who handled that. He's the regular foreclosure counsel for the county. I didn't know about it until I got this court's order asking for supplemental briefing. I haven't been kept in the loop on what's happening in those 78T cases. They've been trickling into my office one by one as they've been resolved, and some of the appeals have been dismissed. Some haven't, like Sheffield in this case. But the whole reason why Howard at the federal level and Hathon at the state level said you have to use 78T first before you bring some challenge to your result under 78T, is so that we could have this answer. What was the result of the 78T claim? That was very explicit in the Howard versus Macomb County Sixth Circuit case. They said, we can't rule on whether you got a constitutionally valid judgment under 78T under the state procedures because you didn't get a judgment. The Howard plaintiff forfeited the claim by not bringing a 78T claim. And Judge Sutton was very clear in the Sixth Circuit's opinion. What's our ground to decide whether you got a constitutional result from 78T if you didn't use the procedure? That was the same situation that Hathon was trying to avoid by saying, first, before you can bring a challenge to the interest and to the 95% recovery with the sale commission taken off, that was the question in both Howard and Hathon, before you can bring those claims, you have to have completed your 78T procedures so that we know what the result was, and then you could contest it. This case that we have here, this one and the Armour case, were started long before they ever brought a 78T claim. The decisions in these cases were made before there was a 78T result. There was no basis for the court to address it, and that's why this case had to be dismissed. The court said, you didn't use 78T. You can't come to me without having used 78T and try to press these other alternative claims. And that remains the situation. You can't press these alternative claims in a case where you hadn't first gotten the 78T result, so we know what we're talking about. The fact that we've had to debate here today what happened in the 78T hearing and what the result of the orders were just shows why this was premature and why you couldn't bring it. I mean, this is precisely the situation that Howard and Hathon are trying to avoid and why this case can't go forward.
But because of all that, can we at least agree that the dismissal should have been without prejudice in the Sheffield case?
Not necessarily. I mean, as far
How
as
can it be not necessarily if she has the right to pursue the 78T case? I mean, if it's with prejudice, isn't there an argument?
well, there wasn't any prejudice
res
to
judicata?
there was no 78T claim here. I don't think
No, I understand that.
resolving these claims, which were substantive due process, procedural due process, Fifth Amendment, all that stuff, that wouldn't affect the 78T claim because 78T was a separate process. If they wanted to start that and bring a 78T claim, I don't know that that would have precluded that. These claims, what we're saying is because you didn't bring your 78T claim first, we're dismissing with prejudice these other claims, conversion, claim and delivery, due process under substantive due process. And of course, we addressed all those in our briefing individually as well, why those claims were never valid. But those are all swept out the door. The question now, I think, just comes down to, as Mr. Visser, I think, said, is whether the 78T case was resolved in a manner that was constitutional. And that's a completely different issue than what we've got here in this case before us now. Like I say, my briefing, including my supplemental briefing, is that this whole mess has been premature. And this is exactly why. Because we're left here guessing what happened in the 78T case. And that's where Mr. Visser says his beef now is that 78T claim didn't give me what it should have given me. I should have gotten interest and I should have gotten the full 100% of the surplus proceeds, not the 95%. I would note on that he's got that a little backwards. Under Raffaelli, as you define surplus proceeds, it is the tax debt plus the penalties, plus the interest, plus the fees reasonably related to the foreclosure and sale. As Judge Redford pointed out, the sales aren't free. That 5% sale commission is simply one more fee that is part of what you lost in the sale. So we're not saying here's surplus proceeds and we're clawing back another 5%. What we're saying is that when you're determining what the surplus proceeds are, the sale commission is part of the fees related to the sale that come out that aren't surplus. They're removed in determining what the surplus will be. So that's a bit of a red herring argument there. I don't know how much, I think pretty much everything else he discussed was covered in my brief at one point or another. I've done so many of these, I've gotten kind of a laundry list that I go through. I would just highlight that on the idea that you have to have first a payment. Well, then our entire income tax system goes down the tube because I pay the state too much every year and I have to go through a process to get it back from what they've taken. They didn't compensate me for my overpayment before they took it. That happens every year. And as far as this, I would also remind the court that we did preserve, if for some reason this case survives, we did preserve statute of limitations defenses, particularly on the federal claims. The 2017 foreclosure case wasn't brought till 2021. We believe we have valid, but we knew there was going to be a lot of fuss as to when there was accrual and all that. And we decided to avoid that and just preserve the defense by mentioning it in our motion rather than have to go through that hullabaloo in arguing it, because at the time, it didn't seem like it would be necessary. Perhaps in light of Schaefer and other things that happened in the meantime, in Hathon, we would have argued it differently, but we still preserve those defenses. And we believe those are in fact valid, especially against the federal claims, which seems to be where Mr. Visser is primarily putting his stock, because the Michigan Supreme Court controls what the Michigan claim can be. And they've said, no, 78T is exclusive for everybody, both pre and post Raffaelli. That's what Schaefer says. And that's your exclusive remedy, whether you like it or not. That's the one you're going to use, and that's the one you're going to have to litigate. So the federal claims, though, I think would be hit by that. There was also the issue that would have also invoked tolling arguments. But we've since had decisions by Judge Maloney in the Western District, which have torpedoed the idea of tolling very effectively. That first was his Felkers versus Kent County opinion, and he's now applied that in multiple opinions, but they're in the Sixth Circuit, Felkers, and I've got one of them, a state of Perry versus Berrien County, where we're arguing over whether or not the tolling analysis by Judge Maloney was correct. But anyway, we didn't press arguments on the reserved statute of limitations defense at this point, precisely because of those problems. But as far as this case was properly dismissed. The claims that were brought should have been properly dismissed with prejudice. And I believe the decision of the court should be affirmed. If the court has any questions, both conceptually about the whole box or individually about specific arguments, I've done a lot of these. I may have an answer.
I need to try something here. I'm sorry. I don't have the expertise of my colleagues. So you're basically saying case should be dismissed with prejudice because it wasn't right. It was premature. Shouldn't have been filed. The dismiss, I understand. The with prejudice is a little harder.
I don't get the with prejudice.
But, and then the other alternative here is, I suppose we could rule, maybe I'm wrong, that the fact that plaintiff got a resolution through a judgment in a 78T claim is that result is constitutional. I suppose we could say that, or we could say dismissal. Maybe this is a version of number one, dismissal without prejudice, and Sheffield could still essentially file a new constitutional claim,
right,
saying that the 78T result and was not, that result and outcome violated the constitutional rights. So that's essentially the version of option one. I kind of wrote them down wrong in my notes, but how did I do on that?
Did well.
Okay.
That last one is why can't, plaintiff Sheffield, you took some money, your state case underlying dismissal with prejudice is upheld. You had some other beef, federal constitutional refile, and then let some other, now that the waterfront is cleared of 85% of the debris from the flood, go back and see what else you can get. Is that a possible remedy that's available?
But wouldn't she have to do that via a motion for reconsideration or some other avenue in that? Otherwise, you got a res judicata problem if she files another action.
Okay. Yep. Okay. And then, all right. So why isn't it all res judicata?
I was
collateral stop.
I was thinking about that too. Is there a collateral estoppel or res judicata problem? I guess if you're arguing this case, this present case was resolved on, you did not use 78T. You are dismissed because you didn't use it. Now, in a separate action, they have used 78T. So now they can say, okay, well, 78T didn't get me a constitutional result. Isn't that a new case?
Almost a remand to dismiss without prejudice might versus with prejudice. I don't know.
Because with candor to the court, I mean, as counsel pointed out, Hathon does say in that footnote that you bring it first under 78T, and then before you can bring your constitutional complaint. Hathon says, I mean, Howard in the Sixth Circuit basically says the same thing.
Okay.
Had you used 78T and not forfeited, as the Howard plaintiff did, then we would have known you'd have your final order for purposes of federal law, and we might have reviewed whether the 78T result was constitutional. So I think that's what we're all kind of dancing around here. I don't necessarily like that, because I just see the whole case go away. But with candor to the court, if you look at Howard and read them, Howard and Hathon, for what they say,
Yeah. Understood.
I think we're probably barking up the right tree again.
All right. Other questions?
No.
Mr. Visser.
Thank you. Please, my brother counsel is consistent. He wants to see all my client's claims go away, but I don't think that's appropriate. There's a concept, Judge Redford, you raised right at the end of my question regarding the cost. I'm not dismissing the cost at all in here. The Constitution is to protect individuals against government overreach. Government gets its cost as part of the administrative fees, as part of the penalties and so forth that are assessed. If most of these sales are done with a 10% buyer's premium to cover the sale cost, they're covered. That's why Michigan Supreme Court and Schaefer said, what's left after those payments? So that's, I think at that point, this court has to recognize what Bauserman said, is you got to protect the interest of the other individuals. I'll represent to this court about a third of the people I know did not get notice either of their hearing, of their processes, even at the beginning, because they were dead. So we can talk about where that leads us and so forth, but you got a whole series of people that aren't willfully not paying their taxes. Some of them just can't reach out of the grave and do it. So that's Judge Wallace, you asked about you had a question about the interest, and we did raise the issue because the Hathon order from March of last year really threw a monkey wrench into everything, because it's just an order, it's not an opinion. It does, I don't know if it qualifies for anything else other than controlling Hathon, but that footnote, you couldn't tell whether it said interest until after the process of the 78T. That's what the footnote says. And I would express to the trial court, what does that mean? Does that mean that you can order the 78T interest on the 78T claim, and therefore it's going to be moot?
Well, the question I have is, did the trial court in that underlying foreclosure action, when your client argued she was entitled to that relief, did the trial court say, I don't have jurisdiction to provide that relief, or otherwise indicate that the court couldn't provide that relief?
Now, what we ended up arguing about that, Judge Wallace, trying to figure out what does that Hathon order do? Is the interest issue here, or is it in another action? And the trial judge bailed on that. Paragraph 8 of the order entered on May 15 of 2026 by Judge Lambrose said, the court is reserving judgment on claimant's request for interest pursuant to MCL 600.6013, pending further developments in the appellate courts or until further motions by the parties. So it comes back to you again. I think we've tried to be very candid with the court that this is a mess.
So isn't the cleanest way for us to deal with Sheffield's case and to simply remand for entry of a dismissal without prejudice and let Judge Lambros handle the issue?
It might well be. I think we do need to have some clarification as to what is that hath, this will be the first court addressing that. What does that footnoted hath on order mean? Is it a binding decision? I hate to say, and I suggested in my brief that it was dicta, but it's really, there's nothing to meet the constitutional standards of that order that it's a compelling, it's a binding decision. So we do need some clarification. Eventually, I think it's going to have to go up to the Supreme Court for them to do some clarification as to what they meant. But this is the first step, I think, in getting there. I do think, the concept of cost and government getting additional money or whatever, I think once you open that door, beyond what Raffaelli says, you run into problems with the distinct statement clause. You can't just simply charge 5% for some perceived cost. Now you got the cost versus fee analysis under the distinct statement clause. So I think that's a problem. Brother Counsel brought up about the IRS refund. I think that's totally an inappropriate analysis as to those payments. The appropriate analysis would be if Brother Counsel came to the court and said, well, the IRS took my entire bank account. Now, do I have to file?
Close to done with your 5 minutes.
So I would also mention reference to Howard. Howard is a post Raffaelli decision. It's totally under had notice. This case doesn't have notice. And the Howard decision on page, I think it's on page 9, clearly says no due process claims were made in that case. So they didn't address those. And of course, we have all kinds of due process claims here in 2017. There wasn't any process at all. And that, again, we're talking not something that can be fixed after the fact, but gives rise to the vested claim. I know I'm out of time, so I'm going to indicate.
That'll be submitted. Thank you.
Thank you, Your Honor.
All right.
Thank you.
Hold next case, Armour versus Kalamazoo County, case case 3-7.
You gentlemen look very familiar.
2-3. All right. And we have Mr. Visser and we have Mr. Curlew.
Again, if it pleases the court, Donald Visser on behalf of the appellates here.
You.
This particular case, again, I come to you with my core understanding, at least what I think is my core understanding of Article 10, Section 2 of the Constitution, as we discussed previously, that it is a disabling feature of the Constitution and controls government. It doesn't just impose a duty on them if they use their eminent domain powers, but disables them from being able to do so. And that's what Raffaelli and a number of other cases have recognized when they say it provides more protection for Michigan residents than what the federal Fifth Amendment does. In fact, on page 454 in Raffaelli, the Supreme Court references the state's ability to take private. That's how it characterized the meaning of Article 10, Section 2. But then because that wasn't an issue in that case, it didn't go on to address it any further. In our brief, we cited the Michigan gas case for establishing the only way to get to a taking is to follow the UCPA. The same thing as in our brief, we recited to Miller versus Michigan Department of Natural Resources. So now the real question.
In the case we just talked about, number 9, Sheffield versus Chippewa County, case 374-645, it was confirmed that 3 of the plaintiffs and appellants had settled and resolved their cases in the entirety, and that the one remaining plaintiff slash felon had gone through the 78T process and received some amount of funds. In this case, are any of the plaintiffs, have any of the plaintiffs utilized any 78T process?
To my knowledge, Your Honor, all have submitted claims to my, I just checked, was kind of looking through it because we had some problems with scheduling. I don't believe we've gotten an order yet on any of the 78T claims denying or approving them. So yes, we have utilized the process. I think that's, in this particular case, I think the briefs were submitted saying that we had not used the process. They were submitted in November, well after the claims, both the motions and the notice which had been given back in March. But I don't think it really makes any difference, again, to the claims that were vested in March, I'm sorry, in the year of the taking. So I don't think you can undo that taking.
Is the fact that all clients and plaintiffs have submitted a 78T claim post the grant of summary disposition without prejudice, is that a matter of record anymore?
I'm sorry, I lost that train. I'm sorry.
Okay.
It's my fault, I'm sure. but-
No, I doubt it. I doubt that it was your fault. I'm sure it was mine. So all the plaintiffs' cases were dismissed
Without prejudice.
without
In
prejudice.
this
correct?
case, it was without prejudice. That's correct.
Okay, so all these cases are dismissed without prejudice. All of these plaintiffs have then turned around and sought the 78T relief. We don't know what the result is. Is that correct?
That is correct.
Is the fact that each of them have made the 78T petitions anywhere present in the record?
I don't believe so.
As an officer of the court and as their lawyer, though, you are acknowledging that that is in fact the status of affairs.
Yes, I am, Your Honor.
All right.
Okay. I understand where the court.
Thank you.
So what we're saying at this particular point is that the government cannot affect a taking through the General Property Tax Act. And that's what, at least that's what they're doing is assuming everyone gets the 95%, they're still taking 5%. That's a taking. This may be a de minimis taking, but there's nothing in this, either the federal or the state constitution that would say.
Right, but the
de
5%
minimis.
is pursuant to the statute, correct?
They're taking it pursuant to a statute that was enacted after the taking. We recently had a Sixth Circuit decision. I think I referenced it in the Sheffield supplemental brief, which found that to be a significant difference in the bankruptcy context, that it amounted to a preference because the government got more than what it was entitled to otherwise. So I don't think, 5% might be de minimis if the surplus proceeds are $23, but if it's $230, and some of these people have a significant claim, including Mr. Singh, which he's quite different than the rest because he's got a 2020 claim. It was 2020. If you look at what happened in 2020, March 31 was the effective date of foreclosure. Then on July 17 of 2020, Raffaelli was released. Then in the fall, the property is sold. Then in December 22 of 2020, 78T is passed, which said you had to file a notice of intention by July 1 of 2020, which was before either the sale or even the Raffaelli decision. I have a case pending in front of Judge Levy right now, and we're past all the summary disposition issues and so forth, where the due process claim still survives because improper notice was not, or proper notice was not given. And the same thing has arrived out of this court in the King County consolidated case that I refer to, Brott versus King County. There's 4 different counties where the court said we have to look at the notices that were sent to determine whether they are sufficient to take the surplus proceeds, which are personal property, versus the notices that were given for foreclosure of the real property. Two distinct properties, and you've got to look at the notices for each of those. And so in this instance, it's clear there was not sufficient notice, because at the time, the FGUs, in this case, the county treasurer, thought that she was able to keep the proceeds, all of the proceeds. And therefore, that itself, that taking violated Article 10, Section 2, because there was no procedure at that time for return or payment or anything else, much less the timing of it before versus afterwards. And the constant, I think, Silver Creek Drain District versus Extrusions Division cited in our case, also Department of Transportation versus Gilling, will say no act of the legislature can take away what the Constitution is given. And in this instance, the constitutional protection goes to the individuals, protecting them from government. As I indicated in response to Judge Redford's questions before, the inverse condemnation cases that I'm familiar with, typically where we're involved with this taking, are in zoning or regulation types of situations, in which the government does not claim ownership, but its actions have simply precluded the effective use of the property. Here, the government is actually trying to grab ownership or possession of the surplus proceeds. Williams versus Reed, as I cited in the last case, says that the state legislature cannot enact any procedural impedance to the 1983 actions under 42 U.S. 1983. And that Congress, by authorizing that, has preempted the states from doing that. So I think that's a problem. Also, Cully versus Marshall says if we're going to look at how In re Muskegon handled the case, treating it as a forfeiture, that a notice has to be given timely after the forfeiture. Those are both Williams versus Reed and Cully versus Marshall are cases that have been released by the United States Supreme Court after In re Muskegon. I think the Bowserman decision, which we have cited, I think in our brief, Bowserman and Mays, but Bowserman being the Michigan Supreme Court decision, imposes on the courts the obligation to interpret the Constitution, and in this case, not defer to the legislative action, but determine whether that legislative action is in accord with the Constitution. And of course, Michigan has passed legislation that is in accord with Article 10, Section 2, and that is the Uniform Condemnation Procedures Act. And that requires payment into court for the payment of just compensation as a threshold gateway to having jurisdiction. This court has dismissed appeals in cases where that was not done for lack of jurisdiction, because again, government just does not have the ability to take absent compliance with the statute. And if you comply with the Uniform Condemnation Procedures Act, the exclusive method under Michigan law to comply with that, you do have to go through that process of determining what the value is and tendering that to the parties. And afterwards, you can have some discussions over whether that's adequate or not. But that is in compliance with a law that exists at the time of your taking. You can't patch that hole after the fact and say, well, now that we really screwed it up, now we're going to try to to pass a law that says retroactively, we're trying to make this payment in accordance with law.
Well, Mr. Visser, let me ask you a question. You, as a very experienced attorney, you're familiar with the concept of bifurcated proceedings in the same civil action, correct?
I am, sir.
Okay. So couldn't these foreclosure courts that have the underlying foreclosure actions, couldn't they comply with that footnote from Hathon simply by handling the 78T issue, and then if applicable, handling any constitutional issues in the second part of the bifurcated proceeding?
I think that's a perfectly reasonable way of handling it. Once we had 78T becoming applicable, absolutely. And then especially in regards to the footnote. And again, I expressed a little consternation about knowing exactly what the scope of that Hathon footnote is.
Is there anything that would stop us as a court from issuing an opinion in this case that essentially says that well, in this case would actually affirm dismissal without prejudice, and in case number 9, remand for entry of a dismissal without prejudice, and simply indicate in a published decision that pursuant to footnote 1 in Hathon, these underlying courts are to conduct the bifurcated proceedings that are consistent with the Supreme Court's order?
I don't agree with that result, but I'm going.
Agree with it.
Because I think for the constitutional claims, they should accrue when they were made and so forth. But having said that.
Right, but
but
hold on.
Okay.
If you don't do it that way, how do you prove damages? Let's assume everything you're asserting is correct on the constitutional theory of liability. If you don't do the 78T first, I mean, let's assume you have meritorious both 78T and constitutional claim. I'm assuming if you have a 78T proceeding, you're going to get back about 80+% of whatever your damages are. And then you're proceeding for the rest of it. Why doesn't it make all the sense in the world to do the 78Ts first, as opposed to at the, simultaneous or, it just seems like it would streamline the litigation so much.
And provide an opportunity for jointly agreeable resolution.
Absolutely.
Judge, your common sense approach is totally on, and that's where I wanted to get with Judge.
And it also eliminates the next 3 years where we're going to be arguing about res judicata.
No, I understand. I think I'm going on purely theoretical, not knowing where this footnote from Hathon's going to end up, saying that I think you really, when you file your lawsuit, that's your time of accrual. That's when your statute of limitation, whenever your rights accrue, you have the right to continue that. But
what it doesn't say you have to file another case. No. It just says what you just said. It says you have to do part A first and then part B second.
That's what the footnote, and that's why the next round of these cases, I'm assuming that this court is going to say either Hathon order applies and the footnote is applicable. But what that's going to mean then is for all of these 78T claims, when they're done with it, that footnote means that their statute of limitations for the remaining claims begins to run at the completion of the 78T. This court's going to hear all kinds of objections to that conclusion from the foreclosing governmental units, because they've been hoping that they put some of these to bed. So that I'm being very honest with you. I don't know how much that footnote in Hathon means, but if it means exactly what it says and it is binding, if it becomes binding, and I'm assuming that what this court says is going to be the case that says it's binding or not, then I think, Judge Wallace, what you're saying, it makes perfect sense of the way to handle it. The problem is, until we get a ruling as to whether that footnote is controlling, whether this order is controlling, because it really does not meet the constitutional requirements for a binding opinion. But if it is, then we have a different set of rules kind of applying, and it says step number one, we go back and we're going to reinstate your claims once you complete the 78T process. And I understand that I can work with those rules, but up until now, I haven't been able to figure out exactly where Hathon's going to end up, because I can see that as soon as we get into making claims for for post 78T relief, that the FGUs will be saying, oh, no, that's not a binding opinion from the Supreme Court. Your statute of limitations it doesn't begin to run at the completion.
And that's the issue, right? Is potentially if to the extent you have constitutional claims, if it's dismissed without prejudice, you're concerned about the government entities making statute of limitations arguments on the.
I am. So if we tie that, correct. If we tie that in with a footnote and says, well, the statute of limitations begins now, as soon as the 78T claim is resolved, now that issue is resolved. But I don't know if I were devising everything, including looking, that's why I mentioned when I asked for oral argument to be reinstated, that there's a dichotomy between federal and state law. I don't know that analysis under Hathon is necessarily going to be binding for an analysis under federal law. It presents some real consternation as I look at these cases going forward, and after that Hathon order came out, what do we really do with this? Sometimes I come to the court with a whole lot of good ideas of where I think things ought to end up. And sometimes, as in this case, I'm coming and saying, I think there's a lot of balls juggling in the air, and we need to have at least a couple of them land so we can use those for anchor points.
They do.
Any questions?
No.
I think I probably wasted the 2 minutes I had. Thank
No,
you.
you didn't waste
Thank
it.
you.
No.
Thank you for your time.
You have plenty of time. You've got time for your rebuttal.
Good afternoon to the panel again. Douglas Curlew on behalf of the county and the treasurers. Let me see if I can address some of these things that I scribbled on my notepad. First, as far as the Hathon order, is it binding precedent? I would say certainly in Michigan it is. I went through the analysis on page 7 of my principal brief, citing the Supreme Court's Dufresne case, saying that where an order on an application sets forth the facts and legal analysis necessary to support the final disposition, such that the order and the context are understood, the order is precedent. So for purposes of Michigan law, at least, I believe the Hathon order is precedent. I've certainly been citing it as such in multiple briefs.
Well, could it be dicta? I mean, it starts out with, we take no position.
Well, that's the footnote says we take no position. To me, that just simply says that you have to bring your 78T claim first. And that's why I was saying with candor to the court, I believe that they're leaving the door open for people then to say that if you've brought your 78T claim and gotten a result, then you can contest it as a constitutional question, which I said was what Howard also says from the federal perspective. So that's perfectly consistent with the order being fully precedential. As far as the statute of limitations, I kind of lost track of where we're headed with that, but I believe the real issue is whether the statute of limitations, because under Michigan law, Schaefer and Michigan Supreme Court decisions are going to control the statute of limitations for any Michigan claim you might want to make. As far as a federal claim, statute of limitations would always be 3 years for a federal claim under through the mechanism of statute or 42 USC 1983. And in this case, their problem is that the last foreclosure was the Monroe White appellant's foreclosure, and that was in 2019. They brought this case in 2024. That's 4 years, some odd months, or 5 years minimum for these people. And that blows a 3-year statute of limitations. And as far as a claim under federal law, say, well, I could have brought a Fifth Amendment claim. Yeah, in 2019, you could have brought a Fifth Amendment claim. You want to say that claim was there and it had accrued? He says he had a vested claim under the Fifth Amendment that he can't take away. Well, if you had a vested claim under the Fifth Amendment or the 14th Amendment or whatever amendment you might want to choose in 2019 or 2018 or 2014, then you had 3 years to bring it and you didn't bring it. You didn't bring it till this case in 2014, so you still got a statute of limitations from your federal claim. So you're still going to lose there no matter what. That's why we preserve the statute of limitations defense. But again, as far as Michigan law, there was mention of the new statute of limitations in the General Property Tax Act 78L. Schaefer dispensed with that. As far as people who are foreclosed pre-Raffaelli, they said you have a 6-year statute of limitations from the date of your foreclosure. That's why all these people could bring these claims, even though they'd been foreclosed before Raffaelli. And if you bring that claim in accordance with Schaefer, you were given the relief from the statute of limitations as long as you filed your proper notice under 78T Section 6. That was a deadline they had to meet. So the statute of limitations is really a red herring that shouldn't impact any question here. As far as the July 1 deadline, which was mentioned early on in counsel's statement, again, Schaefer dispenses with that. That July 1 thing was under Section 2. People who are foreclosed pre-Raffaelli are controlled by 78T Section 6, which Schaefer opened to them. So that's not an issue. His brought case, which is actually in re petition of Kent County Treasurer for foreclosure, brought is an easier way to say it, that dealt with notice under Section 78I. That is for claims going forward. It's what you have to do before the foreclosure hearing. Obviously, no treasurer could have sent notice to any of these people who were foreclosed before the statute was enacted under a notice section that was not enacted at the time. The question is, was there even a statutory notice claim in this case? To the extent notice was ever raised in this case, it was raised as a constitutional question, not a statutory question. The brought case only addressed statutory notice under Section 78I, which can't apply to a case where the timing for it was all long gone before any statute was enacted. And that is actually addressed in my brief as far as notice. A principal brief was addressed pages 17 through 20. I addressed the notice. He cited again the Williams versus Reed and the Cully versus Marshall cases. Those were addressed in my principal brief, pages 11 and 16. I won't rehash why those don't apply. As far as the mentions of the Uniform Property of the Condemnation Act, that doesn't apply here because it is axiomatic that if it did apply at all, which it doesn't, it would be in conflict with 78T, and where statutes are in conflict, you have to go with the statute that is more recent and more specific to the topic at hand. That is addressed at page 13 of my brief on appeal. The controlling statute here is 78T, not the Uniform Condemnation Act. Other than that, the same things I had said previously with regard to the Sheffield case apply here just as much. The case is simply premature, even more so here because counsel admits, and I'm not involved in the 78T claims, the 78T claims haven't even been resolved. So we don't even know what we're talking about as to what the result in those cases would be. Certainly that means it's premature under Howard. It's also premature under Hathon, which is why this case is properly dismissed, because you can't even address these complaints about what the result under 78T when you don't even know what the result under 78T is yet. Anyway, if the panel has any additional question, I'll answer them. Otherwise, I'm just going to start repeating myself.
No, I don't.
I have one hypothetical question. So let's say one of these people in a foreclosure case where the foreclosure was initiated, let's say back in 2018. So they finish up their 78T proceedings, and before the case is dismissed, they file a counterclaim or motion to allow a counterclaim for their constitutional claims and their interest. Let's say the trial court says, okay, fine, I'm going to grant your motion. Wouldn't that defeat any kind of statute of limitations issue because they're bringing a claim in a case that your own client filed back in 2018.
In the 78, in the 78T litigation.
Yeah, because it's brought under that old case number. It's brought under the 2018 case.
Yeah, I don't know how a statute of limitations even applies necessarily when you're bringing it within somebody else's case.
Yeah, I
It
don't
was
think
the
that's
treasurer
what
who
I'm
had a
trying to
statute of
say. I don't
limitations
think it does
problem.
apply.
Yeah, I mean, it was the treasurer who had a statute of limitations issue. Now, maybe the counsel who handles those cases, and I believe it's probably Lucas Middleton, he handles these for a lot of counties. Is it Lucas? I don't know. He may have a different take on that. I don't want to speak for him and
Understood.
foreclose him.
It was just a hypothetical. I'm
Yeah,
not gonna-
because I don't deal with those and he
He
literally
they'll make
deals.
statute of limitations arguments.
No, so I only know statute of limitations as it applies to this case.
Sure.
And I think they're out of luck. So
Understood.
thank you.
Thank you.
Thank you.
Mr. Visser, final comments?
I do. First of all, one correction. I've just checked with my office. Apparently, one of these parties has been settled. I can supplement that to the court. It has not been a 78T order. It has been a settlement. If the court would like me to send that through, I will do so.
Can you get it there today?
I think I can do that yet this afternoon. Yes. Your Honor.
Since I'm PJ, just ask him, you have Ruth's email, right?
Pardon?
You have Mrs. Tommett, my assistant's email.
I don't know that I do. You'll write it out. for me?
No, I'm not.
Okay.
Just send it to the clerk's office. Tell him to bring it to Ms. Tommett's attention. Obviously, anything you send to us, copy counts.
Yes.
And then I'll make sure we
Okay.
get it
I
circulated.
just wanted to
Yeah.
make, because I just checked with the office. So I wanted to make that correction. Judge Wallace, you indicated, I think one of the whole problems of getting this all sorted out, if this all goes back under the original case, we have a whole different set of statute of limitations issues or non-issues, that type of thing, because it's in the original case. Everything's potentially relating back. It's a whole different set of issues. But if this court's going to say these claims have to be filed in the underlying case versus another case, again, we have a lot of unplowed territory here based upon where we're progressing down the road on the 78T claims and so forth. I do want to correct Brother Counsel, at least my take on what he indicated relative to Schaefer controlling things. Schaefer did address some constitutional statute of limitations issues. I want to emphasize our take on that is that Schaefer and Hathon addressed, and this is the main order from 2024 in July, addressed the constitutional claims. Those were the only claims that were involved in the case. You can, the footnotes of Justice Zara indicate what they were talking about. And basically what happened there is with PA 255 and 256, 78L was passed, and that took away the right, to file any claims. This is constitutional, has to go under 78T. They now said, well, 78L is prospective only, but we've lost 3.5 years of claims, so that those people who had claims otherwise, that it's been told for that time period, and they can make their constitutional claims. There were no 78T claims in either Hathon or Schaefer. So obviously the court was not addressing 78T claims there. If in fact we're concerned about statute of limitations in here, I would ask the court then to send it back for development of that issue, because besides Wayside, we have a couple of other class actions, including Calkins,
2 minutes.
that were involved in that were pending, and that would constitute tolling. So when Brother Counsel starts talking about when the claim should have been filed, those cases were filed much earlier than what this case was. This case was filed after Wayside was given preliminary class certification, and those class actions were no longer viable. So I think that covers a couple of things I picked up that at least hit my ear. It may not have hit the court, any of the judges' ears as issues. And I may be down some other path than where you guys are going, but I very much appreciate the judges' attention.
Okay.
Any questions?
No.
Thank you so much.
Thank you. Thank you.
That'll be submitted. This completes panel 6's day one of oral argument in the Michigan Court of Appeals for the month of June 2026. Court is in recess. Thank you.